Mr. Philpott is with us. Excellent.
So yes, I'm here.
Good. There's a couple of things I want to run through briefly, just to make sure that everyone's in the same place, so to speak. Mr. Turney's closing came in yesterday around the appointed time, and it's been circulated. So Mr. Philpott, Mr. Simons, you've both seen it, I take it. Excellent.
Yes, indeed, sir.
Excellent. I also saw some correspondence yesterday about some changes to the 106. I'm content with that. I really don't need to go through that in any detail. Perhaps if we can touch on it briefly after closings, because we'll have to talk about timetable for its submission. I also received this morning, or it might have been yesterday afternoon, some information from Mr. Turney about his availability for site visits. So we'll need to talk about that, but I don't want to get involved in that right now. Perhaps we can do that after closings too. The suggestion, if it helps in the intervening period, is that there's a possibility that we can do it in week commencing 20th of December. If that's possible to accommodate, I'd prefer to do it then than leave it until the new year, because things go a bit cold then. If everyone's available and we can do it that week, then the Tuesday or the Wednesday is fine by me, 21st or 22nd. So perhaps we can confirm that later on. The other thing I wanted to touch on this morning was I heard from Mr. Nichols yesterday, who unfortunately wasn't able to speak the other day, that he would like to address the inquiry this morning, and I'm perfectly happy to accommodate that, obviously. So, Mr. Nichols, unless there's anything else, I'll come to you first. Did you have anything, Mr. Simons?
No, sir, nothing from me. Thank you very much.
Mr. Philpott?
So just a couple of things, if I may. I'll flag them up now. We can perhaps discuss them later. The first point, the 5-year housing land supply note that we provided, I don't know if you've had a chance to have a look at that.
Not in any detail, no.
It's really so, if you do have any questions arising from it, obviously we want to make sure we've got an opportunity to help you with any queries you may have. So perhaps before we formally close the inquiry, if there's anything arising from that you want to ask about, please do.
Okay.
The second point, sir, the Hillingdon judicial review, we need to think about and discuss later on today how we deal with the outcome of that.
Yes.
Because whereas the Holocaust judicial review is so far off that I don't think it realistically is sensible to try and make allowance for that.
No.
It looks, one would expect in the normal course of events that one would get a judgment in the Hillingdon JR by the end of term. Now, there's been nothing said, so far as I'm aware, about exactly when it's going to come. But if that does happen, which would be reasonably predictable, that would be by the 21st. And it would therefore allow for an opportunity for the parties not only to provide you with a copy, but also to say anything more that they want about the implications of that judgment. We've obviously tried as far as we can to anticipate the sort of binary outcome in the evidence, but of course one never knows quite what the court is going to say. And because it goes to whether something is part of one side of the Section 38(6) exercise or the other, we think it would probably be helpful for you to have our views on that.
I think so.
Once we've seen the judgment. And it looks like it wouldn't really lead to any delay in reporting if that were accommodated. So one thing we might want to discuss later when we're talking about the timetable is building in some sort of opportunity to make submissions if judgment is delivered by the end of this term. We don't want to put things off forever, but if it does come, it would seem sensible to build in some sort of process to address you on that point.
I would agree. I think it would assist greatly if one had a definitive answer from the courts on that question. I mean, it's something that's cropping up all over the place. So, and not just in my casework. But yeah, hopefully we'll get some guidance from it. So I think that probably the easiest thing to do would be if it could be drawn to if a judgment comes out, draw it to my case officer's attention, and then what I'll probably do is give Mr. Turney some time, 7 days or something, to comment, and then give yourself and Mr. Simon 7 days after that for any final comments, and then I'll add them as inquiry documents and take it on. I think there's always a question as to when these are matters for the Secretary of State rather than matters for me. But I think if the judgment comes out in a couple of weeks' time, properly, they're a matter for me, and they'd make my reporting easier, because otherwise I'll have to deal with the binary.
Well, exactly. So it seemed to us to be so much more sensible for you to be informed about it, if we can.
I think so.
Okay, well, perhaps we might return to that. So that's a helpful indication of how we might deal with it. So we'll return to that maybe later.
Okay.
Good. The only other thing, so conditions, I don't think that the amended set is quite finalised, but I understand it's going to be finalised during the course of today. So I'm sorry, I don't think that's come to you in its final form yet.
Okay.
I've seen something that shows that good progress has been made, and hopefully that'll be with you soon.
I've literally about 2 minutes ago received an email to say that the updated conditions are, well, maybe not absolutely finalised, but they're very close. Anyway, I think there will be something that's winging its way to pins this morning.
Okay, good.
Those are the matters I had, sir.
Thank you, Mr. Philpott. In which case, I'm going to go over to Mr. Nichols. Mr. Nichols, I'm very sorry to hear about the circumstances around you not being able to be with us last week. No, my sympathies.
Thank you very much. I do appreciate that. Can you hear me okay?
I can, thank you.
Good.
Carry on.
I do really appreciate you jiggling the inquiry schedule so that
Don't worry.
I just wanted to say a few words in support of the planning application. I very much doubt I've got anything to say that you've not heard before, but it might be of interest just because I'm a neighbour and a very close neighbour. I live in Nye Bevan House, right next door to the proposed building. So I'll set out my views. Basically, as I see it, we've got a council wishing to replace a tower block which had reached the end of its life with well-designed and badly needed social housing. Most of it's to be socially rented housing, which is in especially short supply. You know, we know people who are in overcrowded conditions and desperate for such accommodation. This is a rare opportunity to make a substantial contribution to the dire shortage of genuinely affordable housing in the borough. A lot of new development is taking place locally, but as we know, the contribution to the social housing stock from these schemes is often woeful. This is a high density development, and so it should be, in my opinion. This is already a high density estate in inner London, in a location with excellent local services and very good public transport links. To my mind, it's a textbook example of a site where high density residential development is appropriate. Such sites already in public ownership with capacity for new development are in very short supply. Much has been made of the fact that it's a tall building, and there's been a tall building on this site since the 1960s, and this site is on an estate with other tall buildings, some of which date back to the 50s. The Y blocks were the tallest buildings in Fulham when they were originally built. Having said that, it is a very tall building, so the quality of design is particularly important. The new homes are much better designed than the ones they replace, as far as I can see, which is in part why the scheme is higher than the previous tower with its taller ceiling heights and so on. The new scheme is also much more successful than its predecessor in its treatment of the ground floor and its relationship with the surrounding area. And this, to my mind, is at least as important as the overall height of the tower for local pedestrians and users of the building. There will be some additional daylight sunlight impacts on surrounding properties and overlooking of the gardens at Nye Bevan House, which one is ours, as there was from the previous tower. But in my opinion, these negative factors are outweighed by the benefits of the scheme. The tower will be visible from some conservation areas, undoubtedly, as was its predecessor, so the improved design quality is important. It won't affect the main pedestrian views of the facade of the listed St Thomas Church, which is an incredibly valuable community asset along Rylstone Road and St Thomas's Way. But it will obviously be visible in more distant views of the spire of St Thomas's Church. Greg Hands MP has suggested that the scheme may have a serious impact on the local road network. I don't accept this point. Many new residents won't be car owners, and as I understand it, they won't be able to secure parking permits on surrounding streets. The area is extremely well served by public transport, with many essential facilities right on the doorstep. Anyone observing the estate will see that most residents leave their homes on foot to make most of their trips. The scheme will help to improve the quality of public spaces in this part of the estate. The new community room will also be very valuable, complementing the very busy local sports facilities, and the existing community hall, which is, there's currently some difficulties there due to poor maintenance, but it's very well used up to the recent past. The scheme shouldn't be approved if it's incapable of complying with effective fire safety standards. But I've looked through the documents, I can't see any indication that that's the case. And I understand that the fire brigade are content. In summary, I'm disappointed it's taken so long to replace Edith Summerskill House. This borough desperately needs these new socially rented and affordable homes. The principle of high density redevelopment shouldn't be in doubt here, in my opinion. This is a replacement for a tall tower on an existing high density estate in a very well serviced part of inner London. The new building is generally well designed. I urge you to approve this application so that we can see this site redeveloped as soon as possible and progress the regeneration of the Clematley estate. Thank you very much.
Thank you, Mr. Nichols. There's nothing I'd want to ask about that. I think that's I've made a careful note. If you have, have you been speaking from notes?
I have, yeah.
Could I ask a favour? I'll in my report I'll have to summarise what third parties put into me, but it's always helpful if I have a copy of the note that you've spoken to, so I can attach it to my report, so that in due course the Secretary of State can see it. It doesn't need to have your address or anything like that, just your name, so that I can refer to it and then summarise it. If you could send a copy, an electronic copy is fine, to my case officer, to Leanne, who you've been in contact with, then I'd be very grateful.
I'll do that. Yeah, okay.
Thank you very much.
Thank you. Thanks.
Thank you, Mr. Nichols.
Much appreciated. Thanks very much.
Okay. Bye-bye.
Bye-bye.
Next, I'm going to come to Mr. Philpott.
Thank you, sir.
I think I've got your...
I hope that it has reached you. I think it was sent through shortly before we started. So
yes, I have it.
If it has reached you.
It has.
So as will become apparent, and as I'll explain, there are parts of it which I won't read out, but okay. I'll explain that as I go along, if I may. These closing submissions on behalf of the London Borough of Hammersmith and Fulham provide a summary of why the local planning authority supports the grant of planning permission for the proposed development of the site of the former Edith Summerskill house. The context for the consideration of this application is the pressing need for more affordable housing in London and in this borough, and the urgent need to redevelop this vacant and highly accessible brownfield site in order to make a substantial contribution to meeting that need. In the opening submissions made on behalf of the council, the housing need position in London and the borough was summarised in paragraphs 7 to 8. The policies seeking to address that need were addressed in paragraphs 9 to 13, and the public interest benefits of delivering 133 affordable units on the site were summarised at paragraphs 14 to 18. Those submissions are of central importance in this case, and the points made do not appear to be controversial. Subject only to limited updating, in particular the addition of up-to-date information about the housing register, they've been incorporated unamended into these closing submissions for your convenience in reporting on our case. But I don't propose to read them out a second time. And so if I can just then explain, if one turns over the page from paragraph 5 up to and including paragraph 16, those submissions are effectively cut and pasted from the opening. So those are the ones I don't propose to read out, save for this. If I could ask you to turn to page 4, and to the bottom of the page, footnote 18 is where I've inserted reference to the latest housing register position, referring to the document that was submitted as CD 5.3. So that footnote explains the current position of around 3,000 people who qualify for council housing and are waiting to be offered a property in Hammersmith and Fulham. In other words, the position has worsened markedly since the local plan was adopted in 2018. The document also paints a stark picture of the waiting times for properties that are faced by those on the register, commenting that it's difficult to estimate when you will receive an offer of housing. This can be up to 10 years. We know how distressing it can be if you're waiting for social housing. We really appreciate that delays are likely to make a bad situation worse for many people, and we'll always do everything we can to help. So I draw attention to that because that is new, it's an update. But I then turn through to page 7, where I'll pick up the text under the heading Good Design. The proposed development is an exceptionally good design. It would provide an exemplar of what the planning and development process should strive to achieve, namely a high quality, beautiful and sustainable building, enhancing both the local and wider area. Mr. Jones' evidence on behalf of the council has provided an independent assessment that strongly supports the evidence given on behalf of the applicant as to the quality of the design and how it would accord with the requirements of planning policy. This is undoubtedly a well-considered scheme, derived from a proper understanding of an intelligent response to the site and its context. The care and attention given to its design and how it will sit within its local and wider context shines out from the design and access statement and from Mr. Henley's written and oral evidence. In turn, it is reflected in the local planning authority's own independent assessment of what has emerged from that design process. In his oral evidence, Mr. Henley neatly encapsulated the overall effect as a building which celebrates its role in creating affordable housing and is both visually attractive and practical. He has, in Professor Taverner's phrase, adopted an architectural attitude of making the most of the opportunity to create a scheme like this. The scheme would make efficient use of the site, optimizing its potential while skillfully reducing its impacts through thoughtful configuration, articulation, and choice of materials. The device of creating 2 offset, overlapping squares with distinct volumes results in a slender profile similar to the former Edith Summerskill house and a regular grid. This makes for efficient use of the available space, but also translates into a characteristic and attractive regularity of the external architecture. The facade of the building has been designed so as to provide depth and visual interest, allowing the building to be read both as a whole and at a variety of scales when viewed within the surrounding context. This enables the building to respond to that context at different scales and also serves to moderate its scale. The architectural quality and materials are of an exceptionally high standard. Its appearance would greatly enhance the appearance of the Clemathley estate, improving its legibility, the definition of its urban spaces, and its overall townscape and identity. This would form an attractive landmark, substantially raising the bar in terms of the quality of design in a location that already features several large and tall buildings, but has nothing of this quality. A landmark building is appropriate here, marking the location of and an important entrance to a large and important estate of social housing and community facilities, which already features large and tall buildings and has done for over 60 years. That is reflected in the fact that the master planning of the estate included a tall landmark building on this site. The relationship between the building and the public realm would be transformative, not only providing public amenity spaces and enhanced pedestrian routes from St Thomas's Way to the Clemathley estate, protected by the built form and landscaping, but also delivering a ground floor community facility that would be accessed from the end of the arcade along the eastern elevation, activating this frontage and overlooking the play space situated adjacent to it. It is a really intelligent piece of design and placemaking. The proposed building would be visually attractive, adding to the overall quality of the area as a result of good architecture, layout, and appropriate and effective landscaping, would also function exceptionally well. Mr. Henley's evidence demonstrates the thought that's gone into the layout and functioning of the communal areas and the residential flats themselves. By way of example, the clever, generous, and effective approach to cycle storage would encourage and facilitate sustainable modal choice, avoiding the problems clearly encountered elsewhere on the estate, where it can be seen that the residents frequently resort to parking their bikes on balconies, rendering them less useful because of the absence of secure storage elsewhere. The communal areas at ground floor would benefit from natural surveillance and in turn provide natural surveillance of the public realm beyond. The flats would exceed the internal space standards set by the London Plan and the Mayor of London's housing SPG. They would benefit from efficient cores. The majority would be dual aspect with generous living spaces occupying corners for cross ventilation, maximum daylight penetration, and excellent outlook. The incorporation of additional internal space in lieu of balconies produces an overall benefit in terms of safe and usable living space, given the downsides of providing external balconies at height. As explained below by reference to the first of the main issues, the development would sit well within the surrounding built environment, whilst representing an appropriate and beneficial degree of innovation, so as to make optimal use of the site and to enhance an area that currently lacks coherence and is clearly in need of improvement. The sense of place that exists in the immediate area around the appeal site at present is neither strong, coherent, attractive, nor welcoming. In part, of course, that's because the site is vacant and creates a very poor impression of the Clematley estate, with nothing suitable to mark the location of such a significant concentration of housing. In addition, as Mr. Jones has explained, the existing townscape on St. Thomas's Road is very mixed and makes this a suitable opportunity for innovation rather than emulation. The proposed building would deliver a substantial positive change, creating a strong sense of place with attractive and welcoming public realm defined by beautiful and distinctive architecture. The southern facade would be aligned with the adjacent George Lindgren and Nye Bevan houses to create a legible edge to the street with attractive public realm beyond. The building would optimize the site's potential, creating a safe, inclusive and accessible environment benefiting both future residents and those who already live on the estate. The previous scheme, which was almost identical to the application scheme, was subject to independent design review by the Hammersmith Design Review Panel. As Mr. Jones' evidence explains, their response was summarised inter alia as follows. The panel were most impressed by the quality, rigour and invention displayed in this project. The panel supported the elevational strategy. They applauded the rigorous assessment of the design, testing the building in distant and local views and its impact on the interior. Where suggestions were made for further consideration of individual aspects, the design approach was further refined to respond to the panel's suggestions. The end result was said by Mr. Jones to be one of the best social housing schemes I have seen, a step change from what you would expect, and a really high quality and well-designed development scheme. The proposal more than satisfies the policy requirements for good design generally and for tall buildings in particular, both in the framework and the development plan. It is a design of the highest quality and would deliver a substantial benefit to that should be local and wider townscape. Forgive the typo, sir. So I then turn to the main issues. First, impact on the townscape or character and appearance of the area. Introduction. The council has undertaken its own independent assessment of this issue, reflected in section 5.3 of the officer's report, the addendum report, and the evidence of Mr. Jones. So we commend Mr. Jones' assessment of impact to you and the Secretary of State as fair, balanced, and independent. It considers the application scheme as submitted on its merits against the existing baseline of a cleared site. It's not correct to suggest that his analysis is infected by the earlier consideration of the proposals against a radically different baseline. That's from Mr. Turney's closing. And there is nothing whatsoever in Mr. Jones' written or oral evidence which could properly be said to support that criticism. Mr. Jones answered all of the questions put to him by Mr. Turney in cross-examination, an exercise that only served to reinforce the impression that his assessment had been undertaken with considerable care, thought and attention to detail. The weight that attaches to his evidence must reflect that. The same submission could equally be made in respect of the applicant's expert witnesses on townscape and design issues, Mr. Hendy and Professor Taverner, but Mr. Simons is best placed to comment on their evidence in detail. By contrast, Mr. Turney has chosen not to make his own expert witness, Claire Brown, available to explain and answer questions about her own assessment, as he accepted in cross-examination that must necessarily serve to limit the weight can be attached to her evidence. Mr. Turney himself has very fairly accepted that townscape impact is a matter requiring objective, independent expert appraisal and judgment, and that he makes no claim either to having any such expertise himself or to be independent in respect to the development proposals. So next, the existing townscape character and appearance. As Mr. Jones' assessment has demonstrated, and so you'll have seen from your site visits, the townscape character of the area in which the site is located varies significantly. The site itself is vacant, with the adjacent buildings, George Linderham House and Nye Bevan House, significantly set back from St. Thomas's Way. This produces a poorly defined edge to the street, and in its current condition, the site does not present an attractive pedestrian route to the interior of the estate and to the important open spaces and community uses adjacent to its northern boundary, which were evidently intended to provide a focal point between the two tallest buildings within the estate. The northern part of the estate features a cluster of taller buildings. Elsewhere within the estate, the prevailing heights are mixed and of a generally lower scale. The estate suffers from limited provision of amenity space and direct permeable pedestrian routes, leaving it with poor legibility and permeability overall. Looking further afield, the townscape varies significantly. Whilst the areas south of the site are characterised by buildings of a lower scale, these terraces are enclosed by mixed-use commercial developments of various periods, with larger buildings such as the Empress State Building and Ibis Hotel prominent in longer distance views. This is an area whose character has very clearly evolved over time and continues to do so. When the area is considered as a whole, including the Clematley estate, it's fair to characterise it as mixed in character, with a number of tall buildings both nearby and further afield, yet clearly visible as part of the wider townscape. Next, the assessment of impact. The proposed redevelopment of this site with such a high quality scheme, as summarised above, would enrich the townscape quality of the estate, improving its appearance, character and identity, and delivering a meaningful and attractive landmark, aiding wayfinding to and within the estate. As Professor Taverner has explained, the building deserves what he referred to as a civic presence, as an exemplar and gateway to the estate. It will be positive, welcoming, drawing people through and integrating the communities in which it's located. It would provide a source of pride for those who live on this important and populous estate, and that is something the planning system should aspire to achieve when a prominent affordable housing development is created. It would also create an attractive and high quality addition to the wider townscape, whose character already includes a mixture of taller buildings when seen from within lower rise terraced residential streets. The building would relate well to its surroundings at ground level, intermediate level, and in longer distance views. Mr. Jones' evidence has assessed the townscape impact systematically in his proof, reviewing the impact on grouped townscape views, appraising how the development would be perceived within this townscape, and considering the issue of cumulative change. His evidence demonstrates that where the building is visible, the impacts would either be beneficial, reflecting the quality of the design, or negligible. There will be no disruptive and harmful impact on the skyline, which is important when assessing the degree of conflict with local plan policy DC3. On the contrary, it would significantly improve the Clematley estate and make a positive contribution to the local townscape and the skyline of Fulham. Nothing in the analysis and critique provided by Miss Brown caused Mr. Jones to change his views. That is significant because, as he made clear in his oral evidence, he had given careful and repeated consideration to Miss Brown's concerns, both in advising the council's members in respect of the application and in the preparation of his written and oral evidence for the benefit of user and the Secretary of State. It's not possible to know what Miss Brown would have said in response to Mr. Jones' criticism that her own assessment was flawed because there was no proper assessment of the quality of the design and the effect this should have on the assessment of Townscape Impact. There was no opportunity to ask her about this, or indeed about any of the other points she's made. And finally, policy compliance. For the reasons summarised above and set out in detail in our written evidence, the proposed development would more than meet the expectations of the framework in terms of high quality design and comply with the relevant development plan policies, which I list there and don't need to read out. So I then turn to the effect on the setting and thereby the significance of designated heritage assets. First, approach. The Council has undertaken its own independent assessment of this issue, reflected in the officer's report, the addendum report, and Mr. Jones' evidence. Again, we commend Mr. Jones' assessment of impact to user and the Secretary of State as fair, balanced, and independent. He's adopted a structured approach, consistent with the guidance in the framework, the PPG, and the relevant development plan policies. Furthermore, in undertaking his assessment, Mr. Jones has adopted an inherently cautious and conservative approach to the calibration of harm. Pending further guidance in the courts as a result of the litigation concerning the Holocaust Memorial decision, he has therefore, and so I've set out there verbatim from his proof, the description of the approach he's taken. I don't need to read it out because I know that you've read it, but I hope it's convenient to have it there. So the submissions set out above in relation to the weight that should properly attach to Mr. Jones' evidence as a result of his oral evidence apply equally here too, but are not repeated. And his assessment of impact reaches essentially similar conclusions to that undertaken by the applicant's consultant, Mr. Froman. He too has made himself available to answer questions which must increase the weight that attaches to his assessment. So the Council recognises that Historic England has objected to the proposals, and that generally significant weight would attach to its views. In this case, however, there are three main factors which must inevitably temper the weight that is accorded to HE's representations. First, HE has chosen not to appear at the inquiry to explain and answer questions about its position. Second, it has not provided any proper explanation of how it has sought to calibrate the level of less than substantial harm, or where on the spectrum the harm would sit. The MPPG requires such an exercise to be carried out for the purposes of decision-making, and its absence is therefore important. Third, as Mr. Froman explained in his oral evidence, HE's objection is based on an allegation that the harm identified has not been justified. In other words, that the positive benefits associated with the scheme do not outweigh the harm. With respect, that is a conclusion that is not supported by the substantive parts of HE's representation, because it requires account to be taken of those benefits and then a striking of the heritage balance, and HE has not attempted that exercise. Likewise, Mr. Turney has not made his own expert, Mr. Griffiths, available to answer questions. His evidence should attract corresponding reduced weight as a result. Moreover, for the reasons that Messrs. Jones and Froman have given in evidence, Mr. Griffiths' assessment of harm is exaggerated and lacks balance. It should therefore be treated with considerable caution. Mr. Turney himself did appear and made himself available to answer questions, but again, as he very fairly acknowledges, he's neither an expert in relation to heritage, nor can he claim to be objective and independent. So then the assessment of impact and first conservation areas. As Mr. Jones has identified, there would be some less than substantial harm to the setting and therefore significance of the central Fulham conservation area towards the lower end of the spectrum. That judgment as to where on the spectrum the harm would sit reflects the following points. There are already several other large and tall buildings within the Clematney estate and thus within the setting of this conservation area. As such, the introduction of a further tall building would involve only a relatively limited change in the overall setting of the conservation area. Next, the Victorian character, grain and appearance of the conservation area would remain the predominant and legible characteristic of the area and its surroundings. As with the other existing tall buildings, the proposed development would sit in the background in views of the terraces and would not materially harm the ability to appreciate them, either individually or collectively. And And then third, visibility per se is not to be equated with harm. Furthermore, where the proposed building would be visible, the high quality of the design would serve to mitigate any harm. There would not be any harm to the setting or significance of the Walham Green conservation area. Whilst there would be some degree of intervisibility, that does not mean that there would be harm. And as Mr. Jones' evidence has explained, the building would clearly be experienced as a background feature, allowing the key historic buildings and terraces and mixed-use commercial buildings to continue to be experienced and read as part of the established and predominant character of the area. Mr. Jones has also provided an assessment of potential impact on the other nearby conservation areas in his Appendix 1, and for the reasons set out in that document, supplemented by his oral evidence, there will be no harm to the setting of any other conservation area in the vicinity. Next, listed buildings, and first of all the Church of St Thomas of Canterbury and the group of buildings within its curtilage. Mr. Jones has explained why he concludes that there will be less than substantial harm to the setting of the church and to the group of heritage assets within its curtilage. Having regard to what gives the church its significance and the limited extent to which the proposed building would affect the ability to appreciate its architectural and historic significance, his assessment is that the harm is appropriately regarded as sitting towards the lower end of the spectrum. The development would be situated some distance from the church and will be behind the viewer in the main viewpoint from the public realm. The impact on dynamic views of the church from the surrounding streets will be limited and fleeting. As Mr. Jones' evidence has shown, the main adverse impact would be on views from one corner of the churchyard at the rear of the building. From this location, it is acknowledged that there would be some element of competition with and distraction from appreciation of the church. Even from here, however, the impact would be limited, as the development would appear either to frame views of the church or it would be read as a background feature. It would not be the only tall building in the background. Both Herbert Morrison House and the Emperor State Building are already visible from the same viewpoints. The scale, architectural detailing and composition of the church and its spire would remain prominent in the foreground, and the effect on the ability to appreciate these features would be limited. The church was designated as Grade 2 star at a time when the former Edith Summerskill house was in situ as part of its background. There is no suggestion, let alone real risk, that its designation would be affected by the proposed development, which is of vastly superior architectural quality and more sympathetic to the church in its style and detailing than its predecessor. Then the Church of St John Walham Green. The proposed development would not result in any harm to the setting or significance of this heritage asset. Whilst there would be some visibility in mid-range or background views of the church, the development would not be visible within the localised setting of the church and its curtilage. Where the development would be visible, it would have no material effect on the experience or perception of the church. In mid-range and background views, the development would serve to frame the church in a similar way to other existing modern developments, none of which affect the ability to experience the church or its setting. Mr. Jones has provided an assessment of potential impact of the other listed buildings nearby in his Appendix 1. For the reasons set out in that document, supplemented by his oral evidence, there would be no harm to the setting of any other listed building in the vicinity. Then locally listed buildings at Merit, there would be no adverse impact on the setting of any relevant locally listed building for the reasons given by Mr. Jones in his evidence. Finally, policy compliance. The Council has undertaken an assessment that accords with the requirements of paragraph 195 of the framework, and in reaching its own view, it's taken account of the factors listed in paragraph 197. Where harm has been identified, this is less than substantial and therefore falls to be weighed against the public benefits of the proposal. For reasons summarised later in these submissions, in this case, the public benefits clearly outweigh the limited degree of less than substantial harm, and consequently the heritage balance is in favour of granting planning permission. In those circumstances, there will be no conflict with national planning policy. For the same reasons, the proposed development would comply with local plan policy DC8, which incorporates the framework balancing exercise in criterion H. London plan policy HC1 does not incorporate the framework balancing exercise, and hence conflict is generated by any harm, no matter whether it's outweighed by public benefit. Following the approach taken by the Secretary of State in other recent decisions, the heritage balance must therefore be struck in order to form a conclusion as to whether there's compliance with the development plan when considered as a whole. For the same reasons, therefore, the development would comply with the plan as a whole, notwithstanding conflict with policy HC1. So just pausing there, you'll see in footnote 58, I've made reference to the decision on the Citron side. If it's helpful to you, we can supply a copy of that, make that an inquiry document, so you've got that to hand.
I think that might be useful. Yes, a copy of that. I am familiar with that Secretary of State decision and the inspector's report, because I've had it put in front of me a couple of times. That's the site in Hounslow to the north of Kew Gardens.
I believe that's right. So
Yeah.
it was a situation in which there were submissions made about whether or not policy HC1 did or did not incorporate the balance, and it didn't surprise me that you were familiar with it. But I thought I ought to just check, because it would be helpful probably to have it as a document.
I think, yes, just to be able to refer to it and direct the Secretary of State towards it, rather than sort of, I'm sure they could root it out of the archive, but yeah, better if I've got it, I think.
Thank you.
Great, thank you.
So I then turn to London Plan Policy D9C1D and the issue of alternatives. The case advanced by Mr. Turney relies heavily on the issue of alternatives to the proposed development, whether locating the proposed affordable housing, or at least some of it, on alternative sites, and or alternative lower forms of development on the site, which might reduce the harm to heritage assets. This aspect of Mr. Turney's case is not well-founded, either conceptually or having regard to the facts of this specific case. And there are two main points to make in response to this aspect of Mr. Turney's objection. First, this is not a case where either common law principles or the heritage policies of the framework make it necessary to consider alternative sites or proposals as an obligatory material consideration. So I deal with that first. The authorities on alternatives make clear that the circumstances in which alternative sites would be an obligatory material consideration do not include situations where the need is such that a great many sites and planning permissions will be required to satisfy it. As Mr. Justice Simon Brown, as he then was, put it in the Trust House Forte case, the authorities established that land may be developed in any way that is acceptable for planning purposes. The fact that other land exists upon which the development would be yet more acceptable for planning purposes would not justify the refusal of planning permission upon the application site. And he set out the following helpful but not exhaustive approach to identifying the type of cases where alternative sites may be material. Comparability was appropriate generally to cases having the following characteristics. First of all, the presence of a clear public convenience or advantage in the proposal under consideration. Secondly, the existence of inevitable adverse effects or disadvantages to the public or to some section of the public in the proposal. Thirdly, the existence of an alternative site for the same project. I emphasize those words and I'll come back to them, which would not have those effects or would not have them to the same extent. And fourthly, a situation in which there could only be one permission granted for such development, or at least only a very limited number of permissions. In contrast to the situations envisaged above, are cases where development permission is being sought for dwelling houses. The reason for drawing that contrast is exemplified by the present case and the current state of need and supply for housing, and in particular affordable housing in London. In the circumstances summarised above, it is simply not credible for Mr. Turney to suggest that the need here could be met by a limited number of permissions and therefore addressed on alternative sites. The London plan targets are capacity constrained. In other words, even if development took place at a scale that fully utilised available site capacity on all available sites, reflecting current assessments, it would not be enough to meet the identified need. In that situation, any argument based on meeting the need on another site is plainly hopeless. All suitable sites are needed. And the housing that would be delivered on all sites, such sites must be optimised. If another site is developed to its optimal level for housing and affordable housing, that does not, indeed cannot, affect the policy requirement to do the same for this site. Thus, the alternative sites argument is a non-starter. It must fail because it could not, as a matter of logic, make any difference to the appropriate scale of development that is acceptable on this site. That is a case whether one is considering the position as a matter of application of the common law or pursuant to London Plan Policy D9, as to which see further below. In applying the framework's heritage policies, there is no need to consider alternatives simply because harm has been identified to designated heritage assets. And the point is set out clearly and succinctly on behalf of the Minister of State for Housing in the Holocaust Memorial Challenge. And so I don't need to read that out, but what essentially it is doing is explaining why, in the light of the Pew case, it's not necessary to demonstrate an absence of alternatives in order to conclude that harm is justified. A further reason why alternatives would not be an obligatory material consideration in this case, applying common law principles, springs from what was said by Lord Justice Auld in the Mount Cook case. Even in exceptional circumstances where alternative proposals might be relevant, inchoate or vague schemes and or those which are unlikely or have no real possibility of coming about would not be relevant, or if they were, should be given little or no weight. I'm just pausing there so that the Mount Cook case is considering alternatives on the same site. Mr. Turney has chosen not to identify a specific alternative proposal for the site, which he says would represent an appropriate response to this specific site and to the full range of policy, not simply heritage or townscape policy, that is relevant in considering its redevelopment. The closest one can find is the suggestion in Miss Brown's evidence of something of a scale that is transitional between the 2-storey villas to the south and the 3 to 7-storey dwellings on the southern part of the estate. As Mr. Turney confirmed in cross-examination, the suggestion was that the site should be developed at a scale below 7 storeys, but that is the only evidence he deduced as to what scale would be suitable here as an alternative to the application proposal. As a suggested alternative, that fails all of Lord Justice Auld's criteria. It is vague and inchoate, and in light of the development plan policies requiring optimisation and policy H8, there is no realistic possibility that a development of that sort would be approved, even if it was ever thought appropriate to promote a scheme that underutilised the site's potential in that way. It would be a wholly inefficient and wasteful use of a highly accessible piece of brownfield housing land, something that would rightly be regarded as unacceptable in the face of the need and the development control policies that have been put in place to try and address it. In the absence of any detail, it's not possible to know how many units will be delivered in a scheme of that height, but it would necessarily be significantly below what the site provided for over 60 years and flatly contrary to the clear objective of London Plan Policy H8. The second point is that the reference to exploration of alternatives in the new London Plan Policy D9C1D does not bear the weight that Mr. Turney seeks to place upon it. So I then turn to that point. Although the application was prepared, submitted and considered by the Council as the local planning authority at a time when this policy was not part of the development plan, and in circumstances where it was considered that Part C would not apply here, even when the new London plan was adopted, there is no dispute that this part of the policy is a material consideration for the Secretary of State. Depending on the outcome of the Hillingdon Judicial Review, it may fall to be applied as part of the process of determining the extent of compliance with the plan, but in any event, its requirements are relevant when considering the acceptability of the proposal overall. In order to discern what the policy requires and how it applies to the facts of this case, there are some preliminary points to note. The approach to the interpretation of policy is clear and well established. Policy statements are to be interpreted objectively in accordance with the language used, read as always in its proper context. However, policy statements should not be construed as if they are statutory or contractual provisions. Many statements of policy are framed in language whose application to a given set of facts requires the exercise of judgment. The importance of those caveats in avoiding over-legalisation of development control decision-making was emphasised by Lord Carnworth in the Hopkins Home case. It must be remembered that whether in a development plan or in a non-statutory statement such as a framework, these are statements of policy, not statutory text, and must be read in that light. It's also important to recall there's a distinction between the issue of interpretation of policy and its application. Former is a matter of law, the latter a matter of planning judgment for the decision maker. Mr. Wilson was right to draw attention to the fact that the reference to alternatives in Part C, Criterion 1D, does not exist in a vacuum and must be understood and applied having regard to the other elements of the sentence in which that reference appears. The words used are these: proposals resulting in harm will require clear and convincing justification, demonstrating that alternatives have been explored, and that there are clear public benefits that outweigh the harm. The policy does not therefore require heritage harm to be avoided, or for schemes to be refused where the heritage balance shows that harm is outweighed by public benefits, and thus acceptable in accordance with the approach set by national policy. It expressly contemplates the approval of such schemes, as it must in order to be consistent with the framework. The requirement to demonstrate exploration of alternatives must be understood and applied with those points clearly in mind. Equally importantly, the policy does not mandate the nature and extent of the exploration of alternatives that would be required in any individual case in order for the policy expectation to be satisfied. That is left as a matter of judgment for the decision maker on a case-by-case basis. It does not, for example, require consideration of alternative sites in circumstances such as this, where for reasons set out above, any such exercise would be futile and provide no assistance in determining what level of development would be acceptable on this site. Nor does it oblige applicants to explore alternative forms of development which would clearly fail to optimise the site's potential and run contrary to key objectives of the development plan. Mr. Turney's evidence to the Secretary of State is that an optimal development of the site would lead to a scheme of at most 6 stories. In the absence of further detail, not possible to discern with any confidence the likely number of affordable homes that would be produced at that height, but it would plainly involve a substantial net reduction in comparison with what's been provided on the site for 60 years. Any such scheme would plainly fail to optimise the potential of the site, contrary to policy, and would be a non-starter for that reason. Indeed, it's telling that in cross-examination of the applicants and the council's witnesses, Mr. Turney chose not to frame his questions about alternative forms of development by reference to what we now know he considered to be the maximum acceptable height for a building on this site. And that in his written and oral presentation of his case, he chose not to make clear that in his view, 6 stories was the most that could be accommodated here in line with policy. Instead, Mr. Turney's position on this key element of his objection had to be drawn out in cross-examination after the evidence for the applicant and local planning authority had been given. Once it was revealed, however, the patent unreasonableness and unreality of the suggested outcome ought to serve as a very clear signal to the Secretary of State that the underlying approach Mr. Turney has taken to the application of the policy is flawed. Any exploration of alternatives must therefore take place in the context set by the other relevant policies of the development plan, the nature of the development being proposed, in this case affordable housing, and having regard to the particular circumstances of the individual site, which in this case would include the fact that it has accommodated a tall building comprising affordable housing for approximately 60 years. HFS's evidence was clear that alternative forms of development were explored, and in a way that is consistent with the approach I've described and thus entirely appropriate. That is sufficient to satisfy the requirement of the policy. Any suggestion that significantly lower alternative forms of development had to be explored in order to satisfy the policy is therefore misconceived. In any event, the evidence to this inquiry has shown that any such exploration would have yielded nothing that would alter the judgment about the acceptability of the application scheme. There is common ground amongst the expert witnesses to this inquiry that a reduction in the height of the scheme to bring it down to the height of the former Edith Summerskill house would yield only a limited reduction in the level of heritage harm. Of course, Any such reduction would also involve a substantial reduction in the number of new affordable dwellings on the site, and thus in the public interest benefits to be weighed in the heritage balance. Leaving aside for one moment the need to satisfy other policies in the development plan, it should be obvious that consideration of any such alternative is of little use in informing the decision about the application scheme. It's not an alternative way of delivering the same project with fewer adverse effects. It is a different project yielding significantly reduced benefits. The same would be true of a scheme that was lower than the height of the former Edith Summerskill house. Whilst it may be possible to conceive of myriad alternative lower forms of development where both the benefits and harms are reduced in a way that would pass the heritage balance test, that would not alter the fact that the application scheme also passes that test and is therefore acceptable in heritage terms. As explained above, the policy does not require such a race to the bottom, whereby the exploration of alternatives must result in the elimination of harm, or its reduction to the lowest level compatible with passing the heritage balance test. That would be absurd. If the application proposal is acceptable, applying the heritage balance, the nature and extent of the exploration of alternatives that is required should reflect that judgment, and crucially, the wider policy context and the particular circumstances of the application site. That is what happened here, and it was an entirely appropriate way of meeting the requirements of the policy. So I then turn to the other issues. First of all, the living conditions of existing residents of the area. And by way of introduction, I say this. The application is supported by a suite of technical assessments that demonstrate the proposed development would not give rise to any unacceptable impacts on the living conditions of existing residents. No contrary expert evidence has been adduced by those opposed to the development, and there's been no suggestion that HFS's technical assessments are flawed or unreliable in any way. Must therefore be common ground between the main parties that those assessments provide a robust and reliable basis for the Secretary of State exercise of planning judgment in this case. Those assessments demonstrate that the impacts on the living conditions of existing residents would be acceptable. As explained in opening, it's inevitable that any substantial new development on a cleared site in an urban environment will have some adverse effects on the outlook, levels of light, etc., that are currently enjoyed by those living nearby. Policy therefore calls for an assessment of whether the resulting living standards are appropriate or acceptable, and tells authorities that when considering applications for housing, they should apply a flexible approach, applying policies or guidance relating to daylight and sunlight so as to avoid inhibiting the efficient use of sites. A balanced approach is required. So I then turn to daylight, sunlight and overshadowing. The daylight and sunlight report submitted in support of the application demonstrates that there is near full compliance with the BRE guidance, save for a limited number of minor transgressions. Although there would be some instances where the change would be noticeable, that's entirely unsurprising and unexceptional where development is proposed on a cleared site in an urban location such as this. Change on the limited scale that would be experienced here is acceptable and does not give rise to conflict with policy. Mr. Turney's evidence in this respect has been relatively limited. He has suggested that the existence of instances where the BRE guidelines are not met is indicative of overdevelopment, but that point has not at any stage moved beyond simple assertion. There is nothing to show that the resulting conditions would be uncharacteristic or unacceptable. Whilst Mr. Turney sought to criticise the comparator chosen in the assessment itself, Mr. Wilson was clear, in response to cross-examination, that he had considered this issue more broadly by reference to the nature of the surrounding townscape and not just by relying on the assessment of context produced by HFS's consultants. In any event, there's no evidence to demonstrate the resulting conditions would be unusual, uncharacteristic, or in any way unacceptable in an urban environment such as this. There was also a complaint that HFS's assessment did not consider impact on the amenity areas, but that's now being addressed by the submission of a supplementary assessment. That assessment shows that none of the assessed amenity areas experience a reduction in sunlight of more than 20% and are therefore BRE compliant. The majority of amenity spaces assessed experienced no change in sunlight received on the 21st of March as a result of the proposed development. Where there are reductions in sunlight, these are very small, and the amenity area continues to receive 2 hours or more of direct sunlight to well above 50% of the amenity area, and therefore remains BRE compliant. Far from being indicative of overdevelopment, the results show the proposal would give rise to a very limited impact, and the proposed development therefore accords with the policies I have identified. Next, amenity and overlooking. Any substantial development on a cleared urban site such as this is bound to lead to some degree of overlooking. That does not equate to an unacceptable impact, and in this case, the scheme has been carefully designed to limit overlooking and to ensure that no such impacts arise. Beyond the first 5 stories, comparable to the height of the adjoining properties, the angle of the residential windows and increasing height means that future occupiers will not be able to look into the windows of their neighbours, and the scope for overlooking residential gardens will be reduced. The resulting degree of overlooking will be typical of an urban location and entirely acceptable. As Mr. Wilson explained in his oral evidence, given that the site is currently vacant and located in an urban environment, it's inevitable that any efficient redevelopment would result in some increase in overlooking. Furthermore, the proposed building is some 20 metres to the boundary treatment of the nearest adjoining gardens of Hartersmere Road and Fabian Road, which is beyond the 18 metres of separation that's generally regarded as acceptable in the borough. And the proposed development therefore accords with the development plan policies I have identified. Next, microclimate. The applicant's pedestrian level wind microclimate assessment shows the majority of thoroughfares, entrances, roadways and car parks in and around the site will be suitable for their intended use during the windiest season. Where the assessment identified exceptions, these have been addressed through suitable landscaping features and, in the case of location 50, the addition of a planter to restrict pedestrian access. With these measures in place, the resulting wind microclimate will be acceptable. Ultimately, Mr. Turney's concerns in respect of this issue are limited in scope. He notes that there would be some increased level of windiness in the amenity areas during the windiest season, which would mean that at times the conditions in the play space would no longer be congenial for sitting. Play spaces are, however, by their very nature, locations for activity and movement. Any such impact would have only a limited effect on the amenity they provide. During the windiest season, there would also be an increase in windiness at times in the public realm to be created on St Thomas's Way. The precise layout and design of that area is a matter for detailed design, and with suitable mitigation measures incorporated into the landscaping treatment, the effect will be reduced to an acceptable level. The suitable obligation has been agreed and included in the Section 106 to ensure the recommendations of the assessment are implemented, and the proposal would therefore accord with the development plan policies I've identified. Then car parking. The site is located in an area with very good public transport links, as is reflected in its strong PTAL rating. Mr. Wilson has explained that both London Plan and local plan policy expect car-free development as a starting point for all developments in locations such as this. The maximum parking standard within the London Plan for the site is 0. Accordingly, the obligation prohibits future residents from obtaining parking permits. Mr. Turney rightly distanced himself from objections made by other local residents on this basis. Then the conditions for prospective residents. First, the quality of the accommodation. The standard of accommodation provided for prospective residents would be very high. Most of the units would be dual aspect, with generous living spaces occupying the corners, allowing for maximisation of ventilation and sunlight. All units would exceed London space standards. Submitted daylight and sunlight statement demonstrates that all habitable rooms within the proposed scheme would have the benefit of excellent lighting provision. And as I said in opening the council's case, those individuals and families lucky enough to move off the housing register and from unsuitable accommodation into one of these spacious and thoughtfully conceived dwellings would benefit from a substantially improved quality of life as a result. The proposal would therefore comply with the relevant development plan policies. More than that, however, it would deliver affordable housing of an exemplary standard, which is what a planning system focused on achieving good design and meeting the housing needs of present and future generations should aspire to achieve. Then amenity and play space. As summarised above, the private amenity spaces for each unit have been internalised and the required floor space added to the internal layout of the property. This approach has been accepted by the GLA and by the council as appropriate on a constrained site such as this. There are a number of playgrounds and open spaces available within a short distance of the site, and these are judged both by the GLA and the local planning authority to be sufficient to cater for the needs of new residents. In a site located in a densely developed urban area such as this, it is unlikely that a housing development of any scale will be able to deliver the quantum of play space identified by the GLA's play space calculator on site. It's also unlikely there will be scope to deliver that quantum of additional play space on other land nearby. That does not serve as a barrier to development, and could not if the London plan's ambitious plans for housing growth are to be met. The appropriate and pragmatic response must be to look for opportunities to enhance the quality of existing play space and to secure a contribution of funds to be used for that purpose. That approach is reflected in paragraph 546 of the supporting text to London Plan Policy S4. And so I've set that out, but I don't need to read it. Mr. Turney's concerns about the calculation of an appropriate sum of money to be paid towards improvements to local play space appear to have been overcome by the additional information on comparables that the council has provided. The section 106 has also been amended so as to ensure that funds are spent on play space within 100 metres. The amenity and play space provision is therefore consistent with the policies I've identified. But so if you and the Secretary of State were to conclude differently and to find that there was some conflict, it is one to which limited weight should attach for the reasons set out above. Having regard to the existing accessible play space in the surrounding area, the evident scope for it to be significantly improved using the financial contribution that's been secured, any quantitative shortfall against the GLA's play space calculator would not provide a proper basis to turn this development away. Then fire safety. There has been no attempt by objectors, including Mr. Turney, to engage with the contents of the fire statement that was submitted by HFS or the fire statement addendum submitted in order to address the requirements of the then draft London Plan in response to the requests made in the GLA's Stage 1 report. Nor are there any specific points made about alleged shortcomings by reference to the requirements of London Plan Policies D5 and D12. The fire statement and the fire state addendum show that those requirements are met and that the proposed development will achieve the highest standards of fire safety. A development control decision on an application for an individual tall building is clearly not the forum to seek to anticipate what, if any, recommendations may emerge from the inquiry into the Grenfell fire. The London Plan's policies contain detailed guidance on fire safety and are recently adopted. Pursuant to section 38.6, those policies fall to be applied in assessing the issue of fire safety unless and until any additional or different policy emerges through the proper formal processes in due course. Mr. Turney accepted in cross-examination that the proposal would meet the relevant requirements of the London Plan in this respect. Next, whether any impacts on local services or infrastructure will be properly mitigated. First, local services. Mr. Wilson's evidence has explained how the council intends to deliver the infrastructure required to support the growth provided for in the local plan. None of that has been challenged and does not seem to be controversial. He's also summarised the findings of the Education and Primary Healthcare Assessment, which demonstrates there will be no material adverse impact on education or health provision as a result of the proposed development. Again, none of that has been challenged, does not seem to be controversial. The council has a Regulation 123 list that identifies the infrastructure for which provision will be made using SIL receipts and the infrastructure to be provided by means of Section 106 obligations or Section 278 agreements. Mr. Wilson's evidence has explained why it's not considered that any additional infrastructure or contributions thereto are required to make this development acceptable. To set against that evidence, all that was said by Mr. Turney in his proof of evidence was that the absence of an obligation to make a contribution towards local services such as schools or healthcare is surprising given the scale of the development. There was no specific allegation of a likely impact on local services or infrastructure which would be unacceptable if not mitigated by the payment of funds, nor was any specific policy conflict alleged. In other words, there was no attempt to show that any contribution would be necessary to make the development acceptable in planning terms, directly related to the development, and fairly and reasonably related in scale and kind to the development. No further obligation could therefore properly be said to be required in line with the government's policy and the framework. In response to cross-examination, Mr. Turney said that he no longer pursued this as a ground of objection. Then drainage. Whilst Mr. Turney's statement of case included a suggestion that the adverse impacts weighing against the grant of permission included impact on the local sewer network, he confirmed in cross-examination that no objection was maintained in relation to drainage, and this was reflected in the statement of common ground. Mr. Wilson has addressed the issue of drainage in his proof of evidence. He explains why the proposed development is acceptable in terms of its drainage and flood risk impacts, and that appropriate mitigation has been identified and secured by condition. There is no conflict with policy or adverse effect to weigh in the balance. The proposal is therefore in accordance with the relevant development plan policies. Section 106 of conditions. The Section 106 obligation is in agreed form. For the reasons set out in the SIL obligation schedule, all of the obligations meet the tests set by Regulation 122 and within the framework. They are therefore properly sought and provided and may be taken into account as reasons for granting planning permission. There are no outstanding disputes as to appropriate conditions, having taken on board the changes discussed during the inquiry. Next, the heritage balance. The substantial public interest benefits that this proposal will deliver are as listed in Mr. Wilson's proof of evidence and may be summarised as follows. Delivery of 133 much needed affordable housing units, 79% of which will be social rented, with the remainder intermediate. Development of a highly accessible vacant brownfield site. Creation of a high quality building of architectural excellence that will become an integral part of Hammersmith's townscape and a landmark to aid wayfinding. An ancillary community hall for use by residents of the building and wider estate, cleverly integrated with the new and existing public realm to the benefit of both. Improved engagement with the public realm and an improved pedestrian experience and connectivity into and through the estate, and improvements to off-site play space. Those benefits should attract very significant weight, clearly and overwhelmingly outweighing the limited, less than substantial harm to heritage assets that has been identified, and provide a clear and convincing justification for that harm. Accordingly, there is no conflict with national planning policy or the protection of heritage in the framework, and a decision to grant planning permission would be appropriate and consistent with the duty in section 66. Then compliance with the development plan. Compliance with the development plan is to be considered by reference to the plan as a whole, rather than asking whether the proposed development is in accordance with each and every policy in the plan. That approach recognises the fact that individual policies may pull in different directions, and that it would be difficult to find any project of significance that was wholly in accord with every relevant policy in the plan. You, sir, and the Secretary of State will therefore have to make a planning judgment, bearing in mind such factors as the importance of the policies which are complied with or infringed, and the extent of compliance or breach. It is a judgment of the local planning authority that when the development plan is considered as a whole, the proposed development is in accordance with the relevant policies. That was a judgment expressed in the officer's report to committee, and Mr. Wilson's evidence provides a full and detailed explanation as to why it remains his professional judgment now, following the adoption of the new London plan. His assessment acknowledges the conflicts that have been identified with relevant policies, most notably London Plan Policy D9 and elements of Local Plan DC3, and attaches significant weight to that conflict. Nevertheless, having regard to the very considerable extent of policy compliance and the strategic importance of the policies that are complied with, having regard to the objectives of the development plan, the proposed development complies with the development plan when taken as a whole. That assessment has been undertaken on the conservative, that should be assumption, conservative assumption, that no account can be taken of how the proposed development performs against the criteria for tall buildings in Part C of London Plan Policy D9. If in due course the Planning Court finds in favour of the Mayor of London's interpretation of Policy D9, that assessment will turn out to have been too conservative. As Mr. Wilson explained in oral evidence, the implications of such a finding would be significantly to increase the degree to which the proposal complies with the development plan, because it would satisfy all of those criteria to the extent that they are relevant. And then briefly, other material considerations. There are three main other material considerations that should weigh heavily in the balance in favour of the grant of planning permission. The first is that the proposal would satisfy the criteria of both DC3 and D9, the purpose of which is to assess the impact and therefore establish the acceptability of a tall building. Should the Mayor of London's interpretation of D9 be upheld, that element of this other material consideration would then move into the first part of the Section 38.6 assessment, but the assessment against the criteria in Local Plan Policy DC3 would remain within the second part. The second is that the proposal would satisfy both the detail and the thrust of national planning policy in the framework. The third is that the proposed development would make a substantial contribution to meeting the clear, identified need for affordable housing within the borough in circumstances where there's already a significant shortfall against the development plan target. That target has recently increased by a significant amount, and even if met, it would not be sufficient to meet the established level of need. Then the overall planning balance. The proposed development accords the development plan when considered as a whole. Accordingly, the presumption in favour of sustainable development in paragraph 11 of the framework means the proposed development should be approved without delay. The other important material considerations that exist in this case reinforce that presumption. Indeed, they are of such significance and should attract sufficient weight to justify the grant of planning permission, even if a different planning judgment was reached as to compliance with the plan overall. And so in conclusion, for the reasons summarised above and set out in more detail in the Council's written and oral evidence, so you are respectfully invited to recommend to the Secretary of State the planning permission should be granted. So unless I can assist you further, those are my submissions.
Thank you, Mr. Philpott. That's very helpful. I should have said in opening that I noticed Mr. Jones and Mr. Wilson might not be joining us this morning. I hope they're both okay.
Well, I think Mr. Jones is continuing on the path to recovery.
Good.
Unfortunately, Mr. Wilson, I think, has remained rather ill, and I don't think that he's currently actively involved.
Okay.
So I don't know whether he's watching, but it's certainly been, for example, a difficulty in finalising conditions. So he's still under the weather.
Okay. Well, I'd be grateful if you could pass on my best wishes to both. And I was very grateful for them for soldiering on in the circumstances, and admire them for it. But yes, if you could pass my best wishes on, I'd be grateful. But thank you for your help too. I'm going to suggest, Mr. Simons, I hope you don't mind that we have a short break before we come to you. We're at 11:20 or thereabouts. Can we have 15 minutes? And I'll have a quick look at the housing supply document in the meantime, so that I can properly say that there's nothing in there that gives me cause for concern.
You will, sir, have received literally very recently anyway, this conditions document.
Oh right, okay. I can have a quick look at those too.
Yeah, exactly. You've got probably a minute or two to skim through them, and hopefully, my closings should have found their way to you through the good stuff. All right.
Yeah, they're with me. Good. Okay. I'll see you all in 15 minutes.
Thank you, sir.
Thank you. Mr. Simons.
Thank you very much indeed.
Hello. I've got your closing open in front of me. I've also managed to have a quick look at the housing land supply submission, Mr. Philpott, that the council made. It's pleasingly succinct. Thank you. So yes, I'm very happy with that. It sets it out in a very straightforward way. So good. That's fine. I've also had a quick look at the conditions, and I'm content with those too. So I've got a clean copy of those as well. So I'll add the conditions to the list. So I'm at ID 11 now for those. And if Mr. Philpott, I forgot to mention the Citron case, if that can come through at some point. Not in any hurry, doesn't have to be today. I'll add that as an inquiry document too.
So I'll make sure that.
Thank you. Mr. Simons, over to you then.
Thank you very much, sir. Let me just say at the outset, it's a bit of an invidious position following Mr. Philpott, with whom, as you'll see, I agree with almost every word, and he said it as he always does with such clarity. So it's one of those where, sorry if you feel like you've heard some of this before, but anyway, I'll press on. So a tall building has stood on this site for most of the last 60 years. Clem Attlee Court opened in 1957. Pevsner described it as Fulham's post-war showpiece, and as Professor Taverner explained to you, sir, the estate heralded a shift in the character of this area of Fulham towards housing for all as part of the new welfare state which had been born under Clement Attlee. Edith Summerskill House, or ESH, was 68 affordable homes arranged across 18 stories, along with its companion building, Herbert Morrison House, were added to the estate in the early 1960s. They were then two of this borough's tallest buildings. The vision for tall point block buildings on the estate was laudable. It was influenced in particular by French, Swedish, and Danish examples of the early 1950s. However, as we will explain, ESH was a poorly executed building, and the council demolished it for health and safety reasons in 2018 to make way for this scheme. The application scheme is an urgently needed replacement for ESH. It has the staunch support, as we've just heard, of the London Borough of Hammersmith and Fulham, who I'll call the council, and the GLA. It is a building of exceptional quality. So this scheme was one of only 17 projects worldwide to be shortlisted for the World Architecture Festival Future Residential Award in 2019. It will set a new benchmark, not only locally, but regionally and nationally, for what is possible in the development of social housing. It will, as Professor Taverner put it, be a beacon of the estate's regeneration. But the building's not only a wonderful piece of architecture, it will address urgent needs for some of this borough's most vulnerable residents by delivering 133 affordable homes, 105 social rent, and 28 intermediate homes. These will be, in the language of the London Plan, genuinely affordable homes. They've been strongly supported by the GLA. They will make the best use of a sustainably located brownfield site in a way which accords with a raft of local, London-wide and national policies. These needs are profound. Local, London-wide and national policies tell us to meet them in a sustainable brownfield locations exactly like this one. And so I set out here the headings that I'll adopt, but I won't read them all out because I'll read each one as I get there. Okay. That's the structure of the closing. So over the page, the first of those headings is there is an acute and chronic shortage of affordable homes in this borough. The council's local plan was adopted in February of 2018. It paints a portrait of a borough of contrasts, of wealth and deprivation. On the one hand, we find some of the highest house prices in the UK. On the other, 8 of the borough's lower super output areas are in the top 10% most deprived nationally. And sadly, so that includes the Clem Attlee estate. Along with high levels of deprivation, the plan describes a borough which has become increasingly polarised. In particular, the mix of social housing tenants has come to include proportionately more people on lower income, some experiencing multiple deprivation. This deprivation and this polarisation has led to a range of important social ills, including high levels of child poverty and lower life expectancy in less affluent parts of the borough, almost 8 years lower for men and 5.5 for women. More housing and better quality housing is at the heart of the council's strategy to right these wrongs and to improve the health of the local community, which is why the lack of affordable homes for lower middle income households is recognised as a key challenge for the local plan. The council's existing housing stock, which of course includes the Clematley estate, is said to be old, said to be increasingly expensive to maintain to a decent standard. In particular, the design of the council's social housing stock makes it difficult to increase the number of wheelchair accessible homes, and their lack of energy efficiency exacerbates fuel poverty. Recent stock has tended to comprise smaller units, and that leads to overcrowding, and that in turn affects residents' health and well-being. The consequences of the very high cost of private housing in this borough are spelled out in the plan. In the end, sir, many households have no choice but to leave the borough altogether. There were 1,950 households waiting for a home on the council's housing register in 2017, and that number already told a desperate story. As the Secretary of State has said in many decisions, these are real people in real need now, and of course their voices are not often heard in planning inquiries like this one. It's disturbing then to find that this number has now increased to around 3,000, and getting off that list and finding an appropriate home in this borough can take up to a decade. There are many, many more households, and it was 1,374 back in 2017, in temporary accommodation, and 17% of households in social rented housing in the borough are overcrowded. So the picture is bleak, which is why we find at the heart of the local plan's spatial vision and its strategic objectives, the aim to deliver 22,000 homes up to 2035, of which half will be affordable in order to meet the needs of local people, maintain and create more mixed and sustainable communities. And that objective is expressed in a number of policies, including HO1 and HO3 in the local plan. The plan seeks to maximise affordable housing supply. Now, so the borough's challenge became even more acute earlier this year when its housing target was increased through the new London plan. The heart of the London plan's ambition is for good growth, which is to say growth that's socially and economically inclusive and environmentally sustainable. And one of the 6 good growth objectives is GG4, delivering the homes that Londoners need. And that requires many more homes to be delivered, with a strategic target of half of those homes to be genuinely affordable. H1A sets a new target for this borough of 16,090 homes over 10 years. And policy H4 tells us that the strategic target, is that half of those homes be affordable. Delivering more genuinely affordable housing is described as a key strategic issue for London. All schemes are required to maximise the delivery of affordable housing and make the most efficient use of available resources. That's a point I'll come back to. And what is remarkable, sir, is that even that bold strategic target won't actually meet needs for affordable housing, because the evidence showed the true need was for 65% of London's new homes to be affordable. Nonetheless, the position is clear. The development plan requires this borough to deliver over 8,000 affordable homes up to 2031. That's around 805 affordable homes every year. However, average annual delivery of affordable homes in this borough since 2017-18 has been 153 homes a year. So the scale of under-delivery is enormous. The cumulative shortfall in the delivery of affordable homes in only the last 4 years has been over 1,700, which is why the staggering need for more affordable homes in this borough is a point of common ground, sir, at the inquiry. The GLA records an identified need, an identified local need for genuinely affordable homes, and accords substantial weight to this scheme's addressing those needs. Mr. Wilson for the council describes the need for more affordable housing as pressing, and the state of the borough's housing shortage as chronic. Mr. Turney called the need for new affordable housing overwhelming. Mr. Henderson describes the shortfall in the borough's delivery of affordable homes as substantial, and he attributes very substantial weight to the scheme's contribution to addressing those needs. At the national level, sir, this social objective at the heart of the framework requires us to ensure that a sufficient number and range of homes can be provided to meet the needs of present and future generations. Well, that objective is not being met in this borough. The second heading, sir, is that the development plan requires this site to be optimised. Now, the London Plan's second good growth principle is making the best use of land. The need for this approach flows from the rapid growth of London, which of course leads to increasing and competing pressures on the use of space. The plan explains this will mean creating places of higher density and appropriate locations to get more out of limited land. And this objective is set out in policy GG2. We are, sir, in particular, required to enable the development of brownfield land on surplus public sector land and sites on the edge of town centres, as well as utilising small sites, excuse me. We are to prioritise sites which are well connected by existing or planned public transport. We are to proactively explore the potential to intensify the use of land to support additional homes or workspaces, promoting higher density development, particularly in locations well connected to jobs, services, infrastructure and amenities by public transport, walking and cycling. And we're also to apply a design-led approach to determine the optimum capacity, the optimum development capacity of sites. Now, that objective is taken further by policy H1B2 in the London Plan, and that requires us to optimise the potential for housing on deliverable, suitable and available brownfield sites, and especially, sir, sites with PTEL ratings of between 3 and 6, public sector-owned sites, and thirdly, small sites. Higher density development is to be promoted in locations that are well connected to jobs, services, infrastructure and amenities by public transport, walking and cycling. Now, sir, the application site is brownfield. It is on public sector land. It is well connected to jobs, services, infrastructure, etc. We've got a PTEL rating of 4. As you know, that means good. In terms of access to public transport, there are 3 bus stops within a 300-metre walk of the site with very frequent services. The underground station on the district line is 850 metres to the southeast. And we are only 120 metres from the Fulham regeneration area and the Fulham town centre boundary. Now, for those reasons, the principle not only of the site's redevelopment, but of its optimisation is right at the heart of the London Plan's requirements. Now, under the new London Plan, that optimisation isn't some kind of mechanistic function of, for example, a density matrix. So with respect, Mr. Turney's points on comparing this scheme to illustrative density parameters take us nowhere. Rather, the optimisation's got to follow a design-led approach that optimises the site's capacity. And that means ensuring that development is of the most appropriate form for the land use of the site. And I'll return below to have the design work on this scheme met this test. There's a further consequence, sir, of this policy requirement to optimise. In the case of desperately needed affordable housing, when a redevelopment seeks to replace homes, there can be no net loss in the number of new homes. That's made clear in the local plan, and the local plan tells us that when social housing is redeveloped to improve its quality, there should be no net loss of social or affordable rented housing in terms of numbers of dwellings. The aim is also expressed through London Policy H8. Now, all the parties agree that H8 is relevant to this application. Its application must be treated with some care. Subparagraphs A and D I set out, and I won't read out as you've seen them before. Now, read literally, the previous ESH is no longer, quote, existing housing within capital A. Its demolition's already been permitted within capital D. So again, read in a sort of literal way, those provisions are not engaged. But this is something Mr. Philpott touched on. Policies should not be read literally like a contract or like a statute. They've got to be read with reference to their broad purpose and their overall context. And here, that purpose is spelled out in the accompanying text to H8, which tells us, and the emphasis is in the original, that estate regeneration that involves the loss or replacement of affordable housing should deliver, an uplift in affordable housing wherever possible, which explains why one of the Mayor's key requirements set out in the GLA Stage 1 report in this case is that proposals ensure no loss of affordable housing, and of course the GLA found our scheme accords with the approach in H8. It's also why Mr Wilson for the council was right to say that the council in its role as local planning authority would expect a scheme on this site as an absolute minimum to re-provide the affordable homes which were lost when ESH was demolished. And in fact, their delivery should not just be reproduced, but optimised. That part of the requirement to optimise has implications, sir, for the kind of scheme which can come forward on this site, because all parties, including Mr Turney, agree that the site should be redeveloped urgently for affordable housing. Its redevelopment will have been separated by a few years from the demolition of the previous ESH. But this scheme's purpose is simple. It's to replace and upgrade that building. And it would fly in the face of the approach to optimising site capacity for this scheme to do anything other than re-provide and then increase the number and the quality of affordable homes. We are, sir, replacing a building of some 18 stories, which provided 68 homes on a relatively small and constrained site. And that is why applying modern floor-to-ceiling heights and the requirement to optimise the site's capacity, a policy compliance approach to this inevitably results in a building of some height. So the third of my headings, sir, this is an appropriate site for a tall building. Now, in 2016, well before ESH was demolished, the council produced a background paper on tall buildings to inform its next local plan. The purpose of that document was to identify broad areas where tall buildings may be appropriate within the existing townscape setting. Now, the Clem-Attlee estate is noted as part of that existing townscape setting, and the paper explained that the estate includes tall buildings, but the paper did not suggest putting more tall buildings on the estate than were already there. But the function of the paper was to identify areas for new tall buildings, i.e. in the future. See the focus at paragraph 7.1 on any new tall building. The paper didn't look backwards. It didn't evaluate whether areas where tall buildings already exist, like the Clem-Attlee estate, which at that stage still included the previous ESH, were appropriate or not, either for the buildings they already contain or for new tall buildings. In particular, it was silent on the issue of re-providing tall buildings on sites like the Clem-Attlee estate where tall buildings already exist. Now, that 2016 study led to policy DC3 in the 2018 local plan, which says, and I record it for reference, but I won't read it all out. Now, for the applicant, Mr. Henderson accepted that albeit this policy is not explicit, it can reasonably be read as presuming against new tall buildings outside those 4 listed areas in the bullet points. For that reason, this scheme conflicts with DC3 and by extension with policy D9B3 in the London plan. But, sir, we must take care when weighing that conflict. And I say that for 3 reasons. First, at the point that DC3 was adopted, ESH still hadn't been demolished yet. Second, the policy, just like the evidence base on which it's predicated, is silent on the issue of re-providing tall buildings on sites where they already stand. And thirdly, on the contrary, the work on which the policy is based looked forward, i.e. to where new tall buildings could be situated in the borough. It did not reconsider the acceptability of areas like the Clem-Attlee estate where tall buildings already exist. Now, what really matters, sir, is the policy's purpose. That purpose, again, is spelled out in the plan. Policy aims to ensure that tall buildings don't harm the built heritage, townscape character, properly located, contribute in a positive manner, enhance sense of place, integral part of long-term spatial vision for the borough. Now, that's why, sir, we must also consider the extent of the scheme's accordance with detailed development management criteria, both in DC3 and in D9. Because in a case where the building does contribute positively to the townscape, e.g. through an exceptional design, the fundamental purposes behind these policies are not infringed. Now, we consider the building's design below, but it's very high quality, a positive contribution. It will make to the local townscape, sense of place, mean that the core policy objectives of DC3 and D9 are met. That does not obviate the conflict with the letter of those policies, but it should reduce the weight that conflict attracts in the planning balance. Now, just pausing there, sir, I just refer you to footnote 63, where I say something quite similar to what Mr. Philpott said about the Hillingdon JR, which is to say that we've adopted the sort of precautionary approach to D9, which is advocated for by the London Borough of Hillingdon. If the court ends up siding with the Mayor of London, and I've given you the reference to where his position set out, then you would be able, as with the Secretary of State, to reach a view that the scheme accords with D9 overall. And that outcome would, if you get there, sir, only make the analysis in favour of granting consent stronger, not weaker. But alas, we've adopted a precautionary approach for the basis of this closing. Now, back to paragraph 49. So the reason that this DC3 D9 issue is actually a point of dispute at all before the inquiry is because of Mr. Turney's judicial review against the council's previous grant of permission. Now, that grant was quashed by the High Court for the following reason. And as you know, sir, it's about a failure to consider the acceptability of the proposed development against a baseline of a cleared site. That was the point. Should permission be granted for this scheme, as I've said, the demolition of ESH will have preceded its redevelopment by a few years. That means that even though a tall building has been a characteristic of this townscape for many decades, Mr. Turney's right to say that, technically at least, the baseline is that of a cleared site. Now, that has meant, for example, that some of the assessments need to be rerun. And indeed, sir, as you've seen, the relevant assessments have been rerun. But this point about baseline, it does not negate the decades-long history of a tall building on this site as part of its townscape, part of its local character. It does not obviate the requirement to optimise the capacity of the site for the re-provision of affordable housing. It does not somehow render a site which has been appropriate for a tall building for decades somehow inappropriate. And so it definitely does not render a building which was beautifully designed before the JR any less successful after the JR. Mr. Turney suggested that there is not and has never been a successful tall building on the Clem-Attlee estate, but as Professor Taverner made clear, the historic failure was not in the premise of a tall building on this site, it was in the detail of its execution. Let's get real. There's been a tall building on this site for most of the last 60 years. The idea that this site is all of a sudden somehow inappropriate for a replacement tall building is untenable. And again, the clear direction of the London plan is that when affordable homes are to be replaced, the replacements should be at existing or higher densities with at least equivalent floor space. That imperative runs through local, London-wide and national policy. This scheme responds to it with elegance, with ingenuity and with compassion. And it is to that design response which we now turn. The fourth heading then, sir. This building's design is exceptional. This scheme is an outstanding piece of design. Mr. Jones for the council called it a game changer in the quality of affordable housing. He's right. In the future, if permission's granted, this building will come to be just as celebrated as Pugin's nearby Church of St. Thomas of Canterbury, more on which below. It will raise the bar for built form in this part of London. The real genius of the building lies in the overlapping square arrangement of its footprint, its staggered volume, the classical proportions and elevational rhythm of its arched facades, its inner and outer skins. It will make a slender and elegant contribution to the townscape. It will activate frontages at ground floor level. It'll help improve the public realm. Its internal arrangements will create functional and sustainable homes of outstanding quality for its residents. Now, as Mr. Henley explained, there were three ambitions for this project. The first was to respond to the heritage of the Clem Attlee estate and its poignant history in relation to the welfare state and the idea that housing might have a civic property by making a well-designed and beautiful building. The second was to design very high quality, well-planned and well-lit homes in a way which optimizes the site's capacity. And the third was to ground the building in its context through active frontages which shape the public realm using tactile materials and robust details which will age well. So turning first to the estate's heritage, Fulham suffered bomb damage during the Second World War. The application site and the area to the north, previously terraced houses, were razed to the ground. As part of the extensive post-war reconstruction, the estate was built. The first buildings were opened by former Prime Minister Clement Attlee in 1957. Now, Attlee had been the Prime Minister between 1945 and 1951. His government reformed trade union legislation, working practices and children's services. It created a national park system, passed the New Towns Act 1946, and of course, by far his greatest achievement, established the Town and Country Planning System through the Town and Country Planning Act 1947. Now, so each of the estate's buildings is named for a member of Attlee's cabinet. Baronet Edith Summerskill was a doctor and a politician who became a leading figure in Attlee's government. She served as parliamentary secretary to the Ministry of Food and then as Minister of National Insurance in 1950-1951. ESH and its companion building, Herbert Morrison House, were added to the estate in the early 1960s. And at that time, they were the tallest buildings in the area. And as Mr. Henley explained, the master plan for the estate established an important area of open space between these two buildings. ESH was a prominent building, 68 affordable homes, as I've said, arranged across 18 stories. And of course, it met important local needs, i.e. providing affordable homes. But the quality of ESH's design and of its accommodation was poor. As Mr. Henley explained, this generic H plan presented blank gable ends to the rest of the estate and to St Thomas's Way. It appeared to turn its back on the terraced housing to the south. It was made of a reinforced concrete frame, and it had, of course, substandard floor to ceiling heights, and of course it contained asbestos. Turning so to the floor plate, the first moment of genius in the conception of this building was the development of the overlapping square arrangement of its layout. Now, that approach had several advantages. It reduces the building's perceived width, it increases the building's surface area, and that maximizes the potential for natural light and good ventilation, which allows the building to be set back to create public space along St Thomas's Way. Now, the approach has allowed for the framing of more elegant proportions, along with a generous, efficient floor plate. As Mr. Henley explained, this is a building with no corridors. It maximizes the efficient use of space. Its residents will enjoy an unusually generous amount of light. 5 out of 7 homes on each floor will have dual aspect living areas and internal living space. From the entrance foyer to the community room, to the mezzanine, to the cycle storage area, to the efficient but generous arrangements of apartments across each floor, the approach to the building's layout has been meticulous and it has been ingenious. Next elevations, the double square floor plate leads, of course, to a staggered volume. And again, that approach reduces the apparent mass of the building and generates more elegantly proportioned primary facades. The building's characterized by a composition of 2- and 3-story precast concrete volume columns and arches, which are composed to moderate the building's scale, to provide depth and shadow and to enrich its facade. The top of the building's crowned by a projecting open frame and extension of the piers below, softening its silhouette and framing the sky. So this building, sir, it's designed to be appreciated at a number of different scales, from the wider urban townscape to the more localized streetscape, and indeed the human scale at street level. And as Mr. Henley and as Professor Taverner explained, this approach has resulted in a series of well-proportioned relationships in the way that the facades are designed. In particular, the height of the building, I should say building, the height of the building has been tested in relation to the golden ratio. The bays also arrange themselves into different square and golden rectangle proportions, all of which leads, as Mr. Henley put it, to harmonic rhythms running through the building. On Mr. Henley's approach has been to bring together two orders, as he put it, the domestic and the civic. And one of the ways he's done that is by giving the building two skins, meticulously detailed windows overlain by these concrete arches. This approach is, as Mr. Henley put it, the opposite of the utilitarian or functionalist style which characterises so much of England's social housing, a style driven more by procurement procedures than by aesthetic quality. In contrast, Mr. Henley's approach celebrates the role of this building and the lives of the people who will live in it by giving it depth, by giving it richness with texture. The aim is to create, as he said, a building in which people will have pride. This building presents so much more to the world than an assemblage of its functional elements. It has an order, it has a completeness, not born out of functional necessity, but out of the aim to dignify the lives of those who will live in it. The carefully selected materials, different textures of ivory-coloured concrete, bronze, anodized aluminium, window frames, exploits chiaroscuro, the effect of light and shade, which accentuates the three-dimensional form of the building and animates the facade. The facade will be precast, which will ensure it can be constructed efficiently and to a high standard and in a way that weathers well. The wild bond brick at ground floor level will meet the ground with a tactile human scale, and the archways will provide a welcoming entrance to, and indeed permeability through, the estate. The community space will open the building up to its neighbours in the estate and will activate the ground floor. Next subheading, so a design-led approach. As Mr. Henley explained, this scheme took shape over many years of evolution in consultation with the council, the GLA, Professor Taverner, Mr. Froneman, and indeed the public. There was no fixed brief, no minimum quantum to be delivered. What has resulted is a wonderful response to a constrained site, but this is the point, it emerged in a design-led way, always cognizant of the estate's civic history and the requirement of the plan to optimise the site's potential. Mr. Turney repeatedly suggested that the building should have been fundamentally redesigned as a result of his JR. But why? After the JR, the relevant technical assessments were rerun against a bare earth baseline, and there were new assessments on Townscape from Professor Taverner, on heritage from Mr. Froneman. Now, the outcome of that work was positive. The work confirmed, even measured against a bare earth baseline, that this scheme will enhance the quality of the local townscape and only bring about low-level harm to the significance of two heritage assets, more on that below. But far from any showstoppers, the updated work confirmed the obvious: this building is exceptional. Its success does not depend on the point in Mr. Turney's judicial review. So there was no requirement to go back to the drawing board because the updated assessments confirmed the strength of the scheme. Mr. Turney also suggested that the schemes should have produced a separate capacity study for the site. But why? When Mr. Henley's work on the evolution of this design is so much more sophisticated, subtle, and advanced. His design successfully optimizes the site's capacity. It delivers an uplift in affordable homes without any unacceptable harm to townscape, heritage assets, or anything else. And I'll return to some of those points below. And so, sir, to conclude on design, in the end, as Mr. Henley explained, the scheme draws on the area's architectural heritage, and that includes Pugin's concern for the honesty and use of materials and structure, the concrete architecture of Clebatley Court, and the brickwork and details of the terraced houses, in particular to the south. This scheme will raise the bar for the quality of the built form in this part of West London. And as you'll have seen, sir, the architect's attention to detail on everything from materials to textures to internal layouts to proportions and layering of the building's facades has been meticulous. As Mr. Henley said, the scheme's ambition is to create a grounded tower of affordable homes, in fact, a civic building of housing that dignifies the lives of residents and neighbours. That would set it apart, he said, from most welfare state council housing built in British cities in the third quarter of the 20th century, and most affordable housing being built today. That ambition has been met. As Professor Taverner puts it, this scheme sets a new standard for social housing in this country. It's of course been endorsed by a number of independent experts. It's got the strong support of the Hammersmith and Fulham Design Review Panel, which praised its quality, rigour and invention, as Mr. Philpott explained. It also has the support of the GLA, who confirmed that the building's architecture is high quality, it would enhance the local area and it would form an attractive landmark. It's also got the support, of course, of the council's urban design and heritage team leader, Mr. Alan Jones, who you heard from, who praises its design as sensitive, high quality. In particular, Mr. Jones picked out those elegant proportions of its arched facades, the building's strong expression in its base, middle and top, and the framing of its crown, which would make, he thought, a particularly positive addition to the skyline. We all know, sir, national policy is more concerned than ever with the design quality of new buildings. This is it. This is the kind of high quality, beautiful and sustainable building which the government tells us is fundamental to what the planning and development process should achieve. It is no coincidence, sir, that both Professor Taverner and Mr. Jones described this as one of the finest buildings they have dealt with in their careers. It is an outstanding piece of work. And finally, as Professor Taverner put it, the scheme provides an opportunity to step out of the shadows of the past, to raise the character and quality of architecture locally by providing a contemporary exemplar of civic social housing of the highest order. Turn away from that, sir, to my fifth heading, which is that the scheme will make a positive contribution to its townscape. So this building will enrich the experience of this urban area. In views from the north, Herbert Morrison House is normally already in view, as is the Emperor State Building at Earl's Court. Where this scheme is visible, it will be understood positively as part of the Clematley estate and it will provide a positive urban focus. From the south, again, often Herbert Morrison House already visible, but where it is seen, this scheme will provide, again, a positive urban focus. Its interlocking volumes will reduce the visual mass of the building by generating depth to the composition and creating slender elevations. The projecting open frame at its crown will capture the sky beyond. The light coloration of the cladding will soften the skyline silhouette. When it's visible, the scheme's light coloration and high quality detailing will provide a vertical counterpoint to the long horizontals of the terraces. From close quarters, for example, St. Thomas's Way, the rusticated brickwork at the base of the scheme will be visible, as will the entry arcade, and it will provide a colour and a texture contrast with the visually lighter and more slender piers and arches of the residential floors above. From the east, sir, again, the character of the townscape will be enhanced. There's already views of the Emperor State Building, the Ibis Hotel, and other buildings on the Clematley estate. When the scheme is seen, its elegant architectural character and light coloration will complement the eclectic motifs and verticality of the buildings across streets like North End Road. The scheme will provide a positive, if sometimes distant, urban focus. Setting of these streets will be enhanced. Now, from the Walham Green Conservation Area, again, in those places where it is seen, the elegance of the scheme and its light coloration will enhance the character of the street vista, or in some places have only a neutral effect one way or the other. From the west, i.e. the central Fulham Conservation Area, most views will be neutral. There will be some adverse impacts on townscape because of the scheme will be seen in views alongside the church tower of the Church of St. Thomas of Canterbury, and obviously I'll return to that in a moment. The scheme will make positive contributions to longer range views where it will be seen, and of course it doesn't form part of any designated local or strategic views. When it is seen, any views will be incidental. Now, Mr. Turney, whose own evidence on this topic is, on his own admission, neither expert nor independent, tells us that the application site's context is predominantly influenced by the 2 to 3 story terraced housing to the south. Now, as Professor Taverner explained, that is wrong. The application site is part of an estate, and that includes a number of tall buildings, and indeed, you know, a tall building stood on our site for most of the last 60 years. Mr. Turney thinks the transition from our scheme to the Victorian housing to the south is too abrupt. But as Professor Taverner explained, you could go all over London and find this kind of contrast. When it is well done, as it will be here, it does not have to lead to harm. Mr. Turney also relies on something called a TVIA review, which is prepared by Ms. Claire Brown. She was not available, as Mr. Philpott said, for any questions at the inquiry. So her evidence has not been tested. And for that reason, the weight to be attributed to her evidence must be considerably tempered. But in any event, much of the difference comes down to Ms. Brown's repeated assumption, and it is an assumption, that when the building is seen, its impacts will be adverse in nature. But of course, visibility is not the same as harm, particularly for a building as well designed as this one. And as Professor Taverner explained, you cannot divorce the building's exceptional quality from how it will be read in its context. So I turn then to heritage. The sixth heading is the building's impacts on the historic environment are decisively outweighed by public benefits. Now, the scheme would be visible, as was the previous ESH, of course, from certain points toward the west of the cemetery of Augustus Pugin's Church of St Thomas of Canterbury, and from various points in the central Fulham conservation area. That would lead to some low-level harm to the significance of those assets. So I turn first to the church. The church was designed by Pugin, a renowned architect, designer, author, theorist, and leading figure in the English, Roman Catholic and Gothic revivals. It was built in the late 1840s to serve, as Mr. Frohman said, a growing population of Irish immigrants. The church is an example of a building which was intended to serve poorer communities. And there is then, just as Mr. Frohman said, a powerful resonance between the purposes of this church and the purposes of the application scheme. The predominant source of the church's significance lies in its physical form, its design, its proportions, its physical attributes, the fine detailing of its interior, its plan form. Nonetheless, the setting of the church also makes a contribution to its significance. But of course, that setting has evolved considerably. It was originally in an open setting with no development either side, but of course today the church is set in a very tight urban context. The setting includes the cemetery, from which of course other tall buildings, including Herbert Morrison House, can already be seen. Beyond the cemetery, it's difficult to appreciate the church other than on the Rylstone Road itself. There are incidental views of its spire in the wider area, but as Historic England tell us, views of spires are unlikely to make significant contributions to the significance of historic assets unless the views are designed or associative, and of course they aren't here. Now, in some views from the cemetery, the scheme will, as Mr. Frohman explained, distract from and visually compete with the spire. Now, on the other hand, that's not the case everywhere in the cemetery. One already appreciates the urban context of the setting from the cemetery views, including tall buildings. And so this would also be the case for a building on this site of a substantially lower scale. In the end, this scheme affects some views in part of the church's setting, but of course, setting is not the predominant source of the church's significance. The previous ESH was in place when the church was listed. The qualities which led to it being listed will not be harmed by this scheme, so albeit there is some harm, it is low level, less than substantial harm. With respect, Mr. Griffiths' assessment, which was to say high level, less than substantial, it can't be right, because it suggests on the metric he himself sets out in his appendix that most of the church's significance would be vitiated by this scheme. And so that's obviously wrong, not least because most of the church's significance derives from features other than its setting, which would be wholly unaffected by this scheme. Of course, in the end, Mr. Griffiths didn't attend the inquiry. He wasn't open to questions on his evidence. It wasn't tested. And that, as Mr. Philpott explains, substantially tempers the weight that it can be given. I turn next to the central Fulham conservation area. This area was developed in the mid to late 19th century with street patterns of grid-like rectilinear roads bisected by Filmer Road and lined with Victorian terraces. along with associated pubs, churches, shops, and schools. There's a good deal of uniformity in the scale and form of the predominant development, which of course is Victorian terraced houses. The tight residential streets limit extensive visibility of areas outside the conservation area, though there are longer views along certain linear roads. There are views of tall buildings from the area already, so Herbert Morrison House from Fulham Road, Tom Williams House, the Chelsea waterfront. The areas where the scheme would be most strongly juxtaposed with the Victorian townscape of the central Fulham conservation area are the areas around the church. So Ralston Road, East Court Road, Sherbrooke Road. In some views, a tall modern building would distract from the coherence and uniformity of the townscape. However, Mr. Froneman attributes only a small degree of harm, and well within the lower end of less than substantial spectrum in the framework, because this is a relatively large conservation area and many parts of it would just not be affected at all. Even where effects would occur in some of the streets I've mentioned, these would not be in both directions of a particular street, and the distant presence of our scheme would not obscure or obliterate the foreground, the middle ground of townscape and conservation area. Rather, in most cases, it'd be no more than a distant presence that could distract from it. In reaching that view, Mr. Froneman relies on the approach of Inspector Christina Downs, which was endorsed by the Secretary of State in last year's Notting Hill Gate decision. And I've read that out at the inquiry. I think well, it was last week when I was asking questions of Mr. Turney, so I won't read it all out again. But that's the position that we have adopted, assessing in a nutshell the conservation area as a whole and its significance. Albeit, of course, he's not a heritage expert, Mr. Turney suggested the right approach was more complicated than that. It isn't. It matters not if we are considering, as Mr. Turney asked us to, the effect of the tulip on the Tower of London World Heritage Site. It matters not if we are considering the effect of a minor residential extension on a conservation area, his other example. The question posed by Chapter 16 of the framework is the same. And that is to say, as Inspector Downs put it, what is the effect on the significance of the asset overall? To the extent that Mr. Turney and his team depart from that approach, they've adopted the wrong approach to assessing the significance of, in particular, conservation areas. And that may go some way to explaining why Mr. Griffiths identifies harm to so many more assets than both Mr. Froneman, Mr. Jones, the GLA, and indeed Historic England. But the other point that flows from Mr. Griffiths' assessment is that, again, he repeatedly assumes, and it is an assumption, that where the building will be visible, e.g. from Walham Green or Suddlescombe Road conservation areas, that visibility amounts to heritage harm. And of course it doesn't, not only because of the building's exceptional design, but also because the more distant views have no bearing at all on those heritage assets' significance. And again, that is the point which the NPPF asks us to consider. In this field, visibility is not the same as harm. Unfortunately, Historic England's approach to this application was similarly unhelpful, something Mr. Philpotts touched on. Albeit there's an allegation of harm to the Church of St. Thomas of Canterbury, the extent of that harm is not calibrated. And the basis for the objection is that, at least in their view, the harm is not supported by a clear and convincing justification. But that very considerably steps outside HE's brief, because the clear and convincing justification in this case comes through the balance, the heritage balance at 202 of the framework. You weigh the scheme's public benefits, in particular the delivery of 133 affordable homes, against the extent of less than substantial harm. Now, it is well beyond HE's remit to conduct that balance. They lack the expertise, they lack the information to strike the balance. And so it is telling that the bodies who do have the expertise and the information to reach a proper view on that issue, namely the council and the GLA, well, they support the scheme. We return to the planning balance below, but the position's clear. As the GLA and the council agree, the substantial public benefits this scheme will deliver decisively outweigh the less than substantial harm to the church, and from various points in the central Fulham conservation area. For completeness, so albeit in this case, none of the parties allege any substantial harm within the meaning of the framework. Mr. Froneman is right to address the issue as one of planning judgment, which should be informed by the language of the PPG, the Bedford, Bramshill decisions, but is in the end, sir, an evaluative question of judgment for you. And that is also consistent with the very latest word on this subject for from the Minister of State for Housing, and a reference there, so to the detailed grounds of resistance only just received from the Minister of State for Housing in this Holocaust Memorial Challenge, which sets out his position. Now, I turn away from heritage then, sir, to a new point. This point about alternatives, something else that Mr. Philpott had something to say about. The argument, sir, over alternatives ends up, for all the fact I'm going to be talking about it for the next 5 pages, it ends up taking us nowhere. Firstly, the legal and the policy framework. The principles are summarised in the planning court in the Save Stonehenge case, and also the well-known Trust House Forte case from the late 1980s. There are several, but I'll just give you a few which are particularly important. The first is that the fact that other land exists upon which development would be yet more acceptable doesn't justify refusing planning permission. The second is that alternatives are only relevant in exceptional circumstances, and normally only in situations where there's an alternative site for the same project, which would not have the same adverse effects or to the same extent, and there could only be one permission granted for a scheme, or at least only a very limited number of permissions. Third, that position is to be contrasted to cases like ours, where development permissions being sought for dwelling houses. And in those exceptional circumstances where alternatives might be relevant, the courts tell us that vague or inchoate schemes, or schemes which have no real possibility of coming about, are either irrelevant, or if they are relevant, should be given little or no weight. Now, that's what the courts say. In this case, that there is no alternative scheme before the inquiry, there's no alternative sites before you either. So the exceptional circumstances in the case law do not arise. So at least so far as the common law is concerned, there's no obligation to consider alternative sites. There's no relevant policy requirement on alternatives in the local plan, and there isn't one in the MPPF either. So we turn away from the law, the local plan and the framework to the London plan, because Mr. Turney relies on one of the development management criteria in D9C1D of the London plan. And I won't read it out because you've had it read out to you over the course of the last week, but there is a reference in the 3rd line down to demonstrating that alternatives have been explored, ... That policy was not part of the development plan when the application was made. It also, more important, is not relevant on Mr. Turney's own analysis of the case, because on his view, the application fails at the earlier hurdle of D9B, a point I've gone into about not being in the right location, so he says, for a tall building. But in any event, and this is what counts, our scheme accords with that policy. And I say that for the following reasons. First, sir, in relation to alternative sites. Now, this borough, as I've shown you, has a need not for hundreds, but for many thousands of new affordable homes. It is inevitable, stating the obvious now, that this need will not be met by one scheme or even a few schemes. Many schemes will be required to meet it all over the borough, of course. And the importance of that objective, well, we've been over it in the council's local plan. The London plan emphasises the priority on meeting the need in sustainable, well-connected brownfield sites, just like this one. So, unlike the Stonehenge case, unlike the Langley Park case, the need to be addressed by this scheme could never be met by a single scheme or even a handful of schemes. As I say, the borough will need many schemes to address its desperate needs for affordable housing. And that is why an alternative sites assessment in this case is otiose. Because even if one found another site in the borough to deliver 133 affordable homes, that would not obviate either the need to provide several thousand more homes, or the need to optimise this site's capacity to re-provide affordable housing. Been over all of that above. So D9C1D does not, of course, require a consideration of alternative sites. But next, sir, we think about alternative schemes on this site. So the issue is whether or not alternative formulations of the building were adequately explored within the meaning of this policy. And to answer that, we've got to start with the agreed context, because it's common ground among all the parties, including Mr. Turney, that this site should urgently be developed for affordable housing and that its capacity must be optimised. Been over that. Mr. Turney agrees, see his closings, that what previously existed on the site is relevant to what it should now accommodate. Of course he does. As above, we are replacing a building of 18 stories, which provided 68 homes on a relatively small and constrained site. And that's why applying modern floor to ceiling heights and the requirement to optimise the site's capacity, a policy compliant approach to this inevitably results in a building of some height. Again, I've been over that. What matters is how that building was designed. And on that, a number of options for the building were explored over the long evolution of its design. That means, as Mr. Henderson explained in his re-examination, that this policy criterion is met. The alternatives were, yes, premised on a building which increased the number of affordable homes over and above the previous ESH. But that was an inevitable function of the development plan. The alternatives were also premised on a taller building, but given the requirements to optimise the site, maximise delivery of affordable homes, make effective use of a very constrained tall site, that too was inevitable. There's no alternative scheme put forward on this site by Mr. Turney or anyone else. In particular, Mr. Turney doesn't tell us what optimising the site in this case would look like, in his view. How tall a building? How many homes? Nonetheless, on the inquiry's second day, Mr. Turney asked questions which suggested that an appropriate height may be something like 11 stories, i.e. aiming simply to re-provide the number of units lost in the previous ESH. Such a reduction would not, in the views of Mr. Froman or Professor Taverner, make any material improvement to the building's impacts. On the contrary, the building would lose its elegant and slender proportions, the footprint would become more populated, the scheme would lose permeability, it would become denser, it would appear like a slab or a stump, and it would still be visible, in particular from the cemetery. So nothing material is gained by this kind of reduction. But think of how much is lost. Almost half of the most, I should say, important benefit, almost half of the most important benefit proposed through this scheme, 133 affordable homes down to around 68 or so. In any event, of course, no worked alternative before the inquiry showing 11 stories. That's for a good reason. The policy objective in both the local and London plans is not only to match the extensive housing which has gone before, it's to optimise the capacity to meet ballooning needs and to address the policy objective of maximising the delivery of affordable homes. That was 11 stories. But then, under cross-examination by Mr. Philpott, Mr. Turney suggested that an appropriate height for the building, in his view, apparently, and also in that of his Townscape consultant, Ms. Brown, was somewhere under 7 stories. We're talking, sir, at most around then 35 homes. That is a considerable reduction from the previous ESH. And we say, you know, that gives the game away. Because with respect to his considerable experience as a lawyer, and I've got, you know, the greatest of respect for that experience, Mr. Turney's not a planner, and nor is Ms. Brown. The planning policy imperative is clear. The site's capacity must be optimised. The provision of affordable housing must be maximised. For 60 years, as we know, a tall building stood on this site and provided 68 affordable homes across 18 stories. Mr. Turney agrees, see his closings again, that what previously existed on this site is relevant to what should come next. As above, as I've said, the objectives of the planner to increase that amount. Mr. Turney's JR established that the correct baseline for the technical assessments is bare earth. Clever point, sir. Clever point for lawyers. But Mr. Turney tries to use that argument to prise open the most enormous loophole, because he says the demolition of ESH precedes the reprovision of housing by a few years. He says we must now reevaluate whether the optimised reprovision of affordable homes should happen at all. see for that in action the rhetorical question in his closing submissions at paragraph 7. Well, like many clever legal arguments, it stumbles when it meets common sense. As above, Mr. Turney's JR did not obviate the need to optimise this site or to meet urgent needs. The planners, the architects, the consultants charged with delivering this site cannot and should not ignore its history. The demolition of ESH was not some kind of freestanding project. It was always intended that more affordable housing should be re-provided in its place. And of course, there's no prospect at all that either the council or the GLA would actually support a scheme on this site which substantially reduced the amount of affordable housing measured against the previous ESH. The idea that this site should only accommodate a scheme of up to around 6 stories is, again, with respect, not credible. So turning back then to the London plan and to this policy D9C1D, which I've set out above, the clear and convincing justification that we need in relation to low-level heritage harm in this case is provided by the very substantial weight of public benefits. Making good a clear and convincing justification does not require a consideration of alternatives. And I refer you then again to what the Minister has to say about this in the Holocaust Memorial Challenge. Secondly, sir, the building makes an outstanding contribution to the character of the area, then over that. Thirdly, whether alternatives were adequately explored, and I'm there, of course, using the language of the policy, within the meaning of the policy, that's not a question of law. That's a question of judgment. It's one for you, sir, and of course, in the end, it's one for the Secretary of State. And here, we've got the SCI, the Statement of Community Involvement. We've also got the DAS, and we can see through those documents that this design evolved through extensive exploration of various alternative options. The effect was that such low-level negative impacts as the building will have been mitigated and ameliorated so far as they can be by careful and sensitive design choices. And that works, sir, that meets the terms of the policy. Still, an important point, the London plan does not require harm, for example, to heritage assets, to be eliminated altogether. Unsurprising, you might say. But the approach in D9 is comparable to that in the framework, which is to say that any harms have to be weighed in the balance against public benefits. That exercise has been undertaken here, of course, come to it and again in a moment, and the applicant, the council, the GLA all agree that the balance tilts decisively in favour of granting permission. So penultimately, sir, there are no other considerations which weigh against the grant of permission. There are no issues, nothing else, technical or otherwise, which stand in the way of a consent. In particular, Mr. Turney no longer pursues a point about the adequacy of contributions to local services. He no longer pursues a point about the adequacy of fire safety measured against the relevant policy in the London plan. And his closing accepts paragraph 26, technical compliance with existing fire safety requirements. Mr. Turney says that after Grenfell, the Secretary of State will wish to consider, he says, whether buildings of this sort remain an appropriate response to accommodate social housing. He adduces no evidence to support that idea. In any event, a call-in application like this is obviously not the correct forum to conduct that kind of consideration. We are here engaged in the balance of the development plan and other planning considerations required by the relevant legal duties. This is a decision-making procedure. It is not an opportunity to reconsider the wider merits of existing policy. Mr. Turney also no longer pursues any point about flooding or the local sewer network. The consultation exercises in this case are extensive. There's no allegation the procedures fell under the relevant legal requirements or indeed those in the Council Statement of Community Involvement. The scheme accords with the relevant local separation distances in relation to overlooking. The GIA's work has shown the scheme won't cause noticeable alteration to sunlight enjoyed in any of the surrounding amenity spaces. Given the site's urban context, it could never realistically accommodate enough children's play space on site, but we of course have agreed to make a ring-fenced contribution of £50,000 towards local play space, and that's an approach which satisfies the relevant policies, including London Plan Policy S4, to the satisfaction not only of the council but also, sir, of course, the GLA. In terms of daylight sunlight, at the moment, the site's empty, so there'll obviously be changes. But the position is well summarised by the GLA, and in particular, so the final sentence of that long quote, which I won't read out, just says, noting that this is a vacant site within an urban area where there's a reasonable expectation of development occurring, and also that a building with similar impacts existed on the site for some 50 years before it was demolished. The impacts on daylight and sunlight are considered to be reasonable and acceptable. And we say, you know, hear, hear. The council, of course, takes the same view, although Mr. Turney has belatedly criticised some of the consultant's work. He's called no evidence on this topic to suggest that our expert assessment is wrong. Wind conditions around the site would be acceptable with the proposed landscaping and mitigation measures described in the wind microclimate assessment. Again, so this is one of those topics on when Mr. Turney called no evidence to suggest that any of our work's actually wrong, and the position in our reports is supported by the council, it's supported by the GLA. Now, Mr. Turney originally suggested that our scheme's scale was driven by a requirement to replace lost social housing from another scheme in the borough called Watermeadow Court. That idea was not supported by the evidence before the inquiry. Mr. Henley explained that it was wrong. Mr. Turney, I think, called it the biggest red herring in the history of planning inquiries. The driver for this building was providing much needed affordable homes, as you've seen, in order to optimise a sustainable brownfield site. Finally then, sir, with a deep breath, the overall planning balance. Now, all of the parties, including Mr. Turney, agree two things. First, that this site has to be urgently developed for affordable housing. And secondly, that the scheme to achieve that redevelopment has got to respond to the London Plan's requirements to optimise its capacity. Been over that, obviously, in lots of detail. Now, for the reasons Mr. Henderson explains, granting this application accords with the plan read as a whole. It's also supported by a raft of other material considerations, including, and in particular, a national policy in the NPPF, which sets out the government's priority of significantly boosting housing land supply, and requires us to make effective use of land in meeting the need for homes in a way that makes as much use as possible of PDL or brownfield land. And to that end, as you know, sir, the framework requires us to give substantial weight to the value of using suitable brownfield land within settlements for homes. And of course, the framework also puts great weight on achieving well-designed places. And this is a scheme for all the reasons that I've already been through, all the reasons in the evidence of Mr. Henley and Professor Taffner. It meets the criteria at 130 of the framework. For example, it's visually attractive as a result of good architecture, and it adds to the overall quality of the area. Given the acute and chronic picture in this borough that I've been over, again in some detail, in relation to the delivery of affordable homes, Mr. Henderson is right that very substantial weight should be given to their provision here, particularly at such high quality. In the end, this scheme speaks most eloquently to the social objective of sustainable development at paragraph 8b of the framework, to support strong, vibrant, and healthy communities by ensuring that a sufficient number and range of homes can be provided to meet the needs of present and future generations, and by fostering well-designed, beautiful and safe places with accessible services and open spaces that reflect current and future needs and support communities' health, social and cultural well-being. We say it is hard to conceive of a building which better meets that brief. And finally, sir, should permission be granted, the Secretary of State has the assurance of the Peabody Trust, one of London's leading housing associations, 150-year track record, builds around 1,500 affordable homes every year, that this scheme will be delivered, and it'll be delivered soon. The scheme is costed. It is in Peabody's development programme. Funding's in place, subject to this permission being granted. Peabody forecasts starting on site in June of 2022. The low-level, less than substantial heritage harms are decisively outweighed by the scheme's public benefits, in particular the timely provision of much-needed affordable homes and a building of exceptional quality. So the test at 202 of the framework is passed, and in the end, sir, in the language of section 38.6, granting this application accords with the plan read as a whole, and other material considerations lend further support to the grant of permission, even if the Secretary of State decides there's some conflict with the statutory development plan. Other material considerations, in particular the delivery of much needed affordable homes on a sustainable brownfield site in a building of exceptional quality, indicate that permission should be granted in any event. For those reasons, sir, we ask you to recommend to the Secretary of State that the application be granted. Thank you very much.
Thank you. Sorry, excuse me. Thank you, Mr. Simons. Just a few matters that we need to touch on then before I close the inquiry. I don't know whether you were able to make any progress with the potential date for the site visit. Does the 21st or the 22nd appear possible?
So if
Please.
So I've the response I've had from Mr. Wilson and Mr. Jones is that the 21st is possible. Other dates that week I think are unlikely to be, but the 21st would work.
Okay. Mr. Simons?
I don't know yet, sir. So I'm unfortunately sorry about this. I'm going to have to take that away, and we'll have to correspond through Leanne on the 21st. But now that Mr. Philpott said that, I will focus the inquiry onto the 21st.
Yes.
And see if that could work. Because that, I think, does work, doesn't it, for Mr. Turney?
It does, yes.
Right, so that will be everyone other than us then. So I will very much endeavour to to provide enough people. I think as long as we've got, well, I think we do really need Mr. Headley, but then as long as we've got one of Mr. Froman or Professor Taverner, I think that'll be ample. We'll come back to you, sir.
Okay, and what would be useful is if you could liaise amongst yourselves about some sort of itinerary, so that we've got an idea about where we're going, and I would also need some details of the other sites that Mr. Henley might like me to visit to have a look at some of his other work.
Yes.
There was a visit to Hackney.
That's right. That is right. I think there's a couple of. Let me just see if I can find it. There's a couple of sites that he has suggested. I'll send them over to you, sir.
Okay.
Because they're on my messages, but I can't find the link. So I will.
Okay, I'm perfectly happy to do those unaccompanied. We don't need to, everyone to traipse over to East End of London. I'm happy to do those myself. But yeah, if I can leave that with you then, and we'll pencil in. I'll make sure the 21st is clear in my diary and some space for travelling the day before. But that works for me.
Just had a message, sir, that suggests that the 21st works for us. So brilliant. That's good news. So at least we can pencil that in, and we can put that in pen. And I will ask my team to send to you. Well, first, I suppose, to Mr. Philpott and to Mr. Turney, an idea for an agenda.
Yeah, it doesn't need to be anything detailed. A map with some viewpoints. I'll bring my visualizations along with me, and we can go to the various places. And anything I can do unaccompanied, I'm perfectly happy to do that. But I think some parts of it, we need access to the cemetery, maybe access to the church would be useful. If they can be arranged on that day, that would be absolutely perfect.
Brilliant.
And I'm trying to remember the other things. The obligation, yes, that needs to be signed and completed. Mr. Summers, I don't know. Did we talk about 14 days?
I think we did, sir. Let me just confirm. I had a note of 14 days being asked for, which is obviously 14 days. Okay.
Well, I think as long as it's with me, let's say 14 days from today, 21st of December or thereabouts. But I do recognise the difficulties at this time of year. So clearly, if it slips a little bit, I'm relaxed about that. I'm not particularly concerned. The Hillingdon issue, I think we'll leave that I'll keep an eye open as well, but you tell Leanne if the judgment comes out, and then I'll get Leanne to write to everybody, Mr. Turney 7 days, and then yourself and Mr. Philpott 7 days to have the chance to respond to the judgment and to what Mr. Turney says about it, because I think it would be better if it does come out that I take it into account, because my reporting time will start fairly soon, but I'll still be reporting in early January, so there shouldn't be any difficulty with that, and I think it'll make it easier for me, bluntly. So if there is some surety.
On that point, can I just plead for some slight flexibility depending on when it comes out, simply because the 7 days may have unfortunate coincidence with Christmas, and
it may well do.
What might therefore be sensible is once it comes out, if the 3 advocates, as it were, can liaise to agree what would be a sensible timetable.
Yeah.
That allows us all to do justice to it, and then we can contact Leanne with the judgment and with that timetable.
Perfect.
Hopefully in agreed form.
Perfect. Yeah, I think that would be better than me setting anything out yet, and I certainly don't want to involve people working on it over the Christmas period, because well, hopefully I won't be, but I can't say for certain, but hopefully I won't be. I'm just wondering, is there anything else we need to deal with? Mr. Simons, did you have anything?
No, I don't think I do, sir.
I think there's no documents other than the Citron case.
No.
I'll add that to the list of documents. Good. The only other thing for me to do is to thank you all, and to Mr. Turney, who may be watching this on catch up for the way it's been conducted. I think we've been very efficient with the use of time. We did originally think we'd need a couple of days this week, maybe. So yes, we've got through the evidence in an economical way, but it's been well put. So I'm grateful for that, and for the way that the cases have been put. So my thanks.
Thank you, sir.
Good. Well, in which case, I'll wish you happy Christmas. Hope you have a good one. And Mr. Philpott, please pass on my best wishes to Mr. Jones, Mr. Wilson, for a speedy recovery.
Absolutely.
Right. I'm going to close the inquiry then. I'll leave you.
Thank you very much, sir.
Thank you for your company.
All the best. Thank you.
Bye-bye. Thank you.
Bye.
Bye-bye.